That's us just gone live now.
Right, well, welcome to this 17th day of the Clauchrie wind farm inquiry. Today we're continuing our discussion of radar mitigation matters. I've heard from Mr. McLeod and Mr. Brown already, and I can see Ms. Kilpatrick is there waiting. I won't make the announcements I've made previously regarding such matters as webcasting and COVID procedures and so on. If people want to see those, they're available on the webcast the 24th of May. If there aren't any other procedural matters anyone wishes to raise at this stage, then I'll just turn to Mr. McLeod, please, for your questions for Ms. Kilpatrick, please.
Thanks, sir. Morning, Ms. Kilpatrick.
Morning.
You can hear me okay?
I can indeed.
Good. I just wanted to start by picking up a point that had come up in your examination in chief. And you mentioned in the context of TERMA that the life cycle of the radar was 10 to 15 years. Is that your understanding of how long a radar system should last?
Well, we've taken advice from experts, and you'll hear from Mr. Fido shortly. And the advice that we have received from our experts is that we should expect, going forward, the life cycle of the radar to be between 10 to 15 years.
And what's your understanding of the life cycle of the existing primary radar?
That its life cycle's been significantly longer than 10 to 15 years.
Yes. And you'll have read your own air traffic controllers' evidence that describe that radar as moving towards the end of its life. Are you still with us? You're buffering a bit at the moment. I think Ms. Kilpatrick's dropped off, sir.
Yes, that seems to be the case.
Yes, sir. Ms. Kilpatrick just got into the room to find out if there's what the problem is. My apologies, sir. I'm told that we'll have to change the laptop again. I'm sorry about that. We thought it was working.
Yes, it seems to be the same problem as yesterday, but it was fine yesterday after we did the switch. So
Yes, I'm sorry about that, sir.
okay, well, we'll wait that however long it takes. Yeah.
I'm back.
Can you hear me okay now?
Yeah, I can hear you now. Yeah, I can hear you now. Switch laptops.
Okay. So I'm not sure whether you heard the question that I put to you, so I'll just start again with it. We were talking about the lifetime or the life cycle of a radar system. And I put it to you that your own senior air traffic controller had described the existing primary radar as moving towards the end of its life. And you'll have heard that evidence, presumably.
Yep.
And in short, the existing radar needed replaced. It was well past its sell-by date in layman's terms, wasn't it?
Well, I would say it was coming towards the end of its life, yes.
Do you know when it was installed?
I couldn't tell you the exact date, no.
Okay. Would you accept it's significantly longer than the 10 to 15 years that you described in your evidence as the life cycle of a radar system?
Yeah, I think I've already just said that earlier. And I think the point to make here is that I described the life cycle of a radar going forward to be 10 to 15 years, not that the life cycle of a radar in the past was 10 to 15 years.
I see. So are you saying that there's a technical distinction and that the previous iteration of the radar was more robust?
No, that's not what I'm saying. I'm telling you that we have sought advice from experts as to how long we can expect a radar in the future to last. And that advice is that we should expect the radar to last 10 to 15 years. Now, you can obviously ask Mr. Fido on what basis he makes that judgment, but technical judgment, but that's the advice that we've been given.
And are you aware of, maybe before your time, but you're aware of any advice that was given to you about the lifespan of the existing radar and its need for replacement?
No,
So
that would be,
when
no. When you say the existing radar, you mean the S511?
I do, yes.
Yes, no, that's for my time, so I'm not aware of any advice that we would.
Okay, well, let's move on to a slightly different topic, please. I'd like you to have a look at a document you've probably not seen before, which is it's CD 11.2, and it's the Scottish Government circular on conditions.
I'll need to wait for Miss Cornelius to actually. I don't think we have a list of documents. If you Miss Cornelius has just told me that they're printing a copy for me now.
My apologies. Excuse me. It may be that we can take the questions slightly out of order, and it may also help if I tell your team that the other documents, main documents that I'm likely to refer to, are APP 3.5 and CD 9.3. But we'll probably not get to those for a while yet. I wonder, while we're waiting for the circular to arrive, I'll maybe just put some general questions to you about your approach. And as I understand it, your position is that a condition should be imposed on any consent granted that requires an agreement with you, with the airport.
Yes.
And that agreement will require financial payments to the airport.
Yes.
And the level of payments, or the acceptability of the payments, I should perhaps put it, the acceptability will be determined by you.
Well, the acceptability is a result of a negotiation that would take place between the airport and the developer. So there would be, some discussion to reach a position that is deemed to be acceptable.
But if that discussion did not result in an outcome that was acceptable to the airport, you would clearly not sign that agreement, would you?
Well, no, we wouldn't sign that agreement.
So in effect, you hold all the cards.
Well, no, because I think there's a couple of things we need to consider here. This situation arises as a result of the developer's commercial activities. They have a direct impact on the airport's operations. And the result of that impact, and the result of the impact needing to be mitigated, is that the airport will incur additional costs that it knows about, and it will also be exposed to significant risk for a long time. Now, it is perfectly reasonable for the airport to expect that it should not bear the costs and the risks that come as a direct result of the developer's activities. So the imposition comes from the developer. We do not get a choice about whether or not, where the development is built or how big it is. That risk to us is imposed. Now, clearly, we have to reach, some agreement. And if we, as two commercial entities can't reach that agreement, then the developer has options. They can call it into the regulator, and somebody independent could mediate. So I don't think it's just as clear cut as you're portraying here. I think there are other options that the developer can seek to help arbitrate that process.
Well, we'll come to all of the points that you've raised in that in detail in due course. But at this stage, just to be absolutely clear, you determine the acceptability of the payments and therefore whether you will enter into the agreement. That must be correct, surely.
Yes.
And your position is that if you're not able to reach an agreement, then the developer should be looking to the regulator, that's the CAA presumably, for them to exercise a mediation role.
No, I'm saying that there are other, I think we need to bear in mind here that we work with a lot of developers, have worked with a lot of developers over many, many years to find a solution to mitigation. And we have managed to reach acceptable solutions with a lot of developers to date. So, there is a process of negotiation that goes on because there is an imposition of risk that takes place when those wind farms are built in the environment. And it is perfectly reasonable and right and proper that the airport should seek to not be financially exposed as a result of somebody else's commercial activities. So there would be a negotiation that takes place between the two parties where, the airport would talk about its view on the costs and the risks and, the price that needs to be borne by the developer in lieu of that.
And how much are you looking for this developer to pay per year?
Well, as you know, Mr. MacLeod, we've tried on numerous occasions to, get to a position where we could share the full terms of the agreement. That process started in November. last year, and I think the applicant has been very clear that their position is that mitigation isn't required and therefore they don't need to see the agreement. So again, we would welcome the opportunity to have a discussion with the applicant about the terms, but the place to do that is not, in a public forum.
Respect, Ms. Cornelius, it is. My clients say that there is no need for mitigation. You say that there is. What I'm asking you now is, what is the level of mitigation that you say is required?
Well, as I referred to, well, first of all, I would just say, that these are, not huge sums of money, and we would have welcomed the opportunity to have shared the details with the applicant so that they were fully aware of the level of charge that we're talking about here, because it is not material. Unfortunately, that hasn't happened, but I hope that at some point in the not too distant future we are able to share the full terms of the agreement and have a conversation about the charges that were within that. But you'll also remember that yesterday we talked about NDAs and confidentiality, and I am bound by confidentiality agreements that are already in place on agreements that mean I cannot talk about the charges that we levy in a public forum.
Well, to be clear, there's no confidentiality agreement between the airport and the applicants, is there?
No.
So my question to you is, what level of charge, annual charge, are you looking for the reporter to sanction, in effect, through this process?
Well, I've already answered that question, Mr. McLeod, and I've already explained that that is commercially sensitive information, and it is not something that the airport is prepared to share in a public forum.
Okay. Your position, I mean, I've heard you refer a number of times to exposing the airport to cost, ongoing cost and risk. Your recognition makes it quite clear that we're not looking at a cost recovery situation. Are you willing to accept that?
Yes, and I think I've mentioned that yesterday. I think we covered that yesterday.
Yeah. So the annual payment that you're looking for has nothing really to do with cost recovery as far as the airport's concerned.
Well, I think there are a couple of points there. First of all, cost recovery, as I see it, would mean that we would have to value the time and effort that our staff dedicate to wind farm related projects at cost. So I made that clear yesterday. Our employees are, like any employees, are there to add value. So we value their time over and above what their salary is. So by definition, that is not cost recovery. And the airport should not be, should not be expected to provide its time that it could use in different ways on a cost recovery basis. So, to that point, no, it's not cost recovery. But I think the bigger point here is we are talking not just about cost, and I think this is where the big disparity of opinion lies, that the airport is weighing up costs that it can see are likely to happen, but it's also having to factor in long-term and significant risk. Now, risk by definition cannot be quantified. So there is no post-dated invoice that we've got to, tot up and work out a figure. We as a business, as a board, having a responsibility to our shareholder, have to take a view on what the level of that risk is and what value we think is acceptable to cover that long-term risk and costs that we know that we will bear. So it's not a simple exercise of cost, it's about risk.
Okay. And what level of risk is the airport willing to bear? Is it any risk at all? Or you remember that, or you may have heard the cross-examination of Mr. Thompson when we talked about risk and the qualitative and quantitative aspects that need to be taken into account. What level of risk does the airport accept?
Well, I mean, the airport has to accept a level of risk, that occur as a result of it pursuing its own, business activities, as does any business. But what isn't reasonable to expect is that it has, any tolerance for risks that are imposed on it as a result of somebody else's commercial activities. So, wind farms are not, this is not, it's not part of our business. We have no commercial interest in wind farms, and yet when they are built in our environment, they bring risk and cost. So no, we should have no tolerance to risk that comes as a result of somebody else's commercial activities.
Okay, but you accept that the risk of operating the radar lies with the airport. That's part of your cost of doing business.
Yes.
Okay. Can I ask a more general question? You're obviously unwilling to talk about the level of payment that you would seek to extract in this case from my clients.
Can I just sorry, I just
Oh, let me-
make a point here that we have been willing to share the costs with the applicant for some time. So it's not that we're trying to hide anything. We have actively tried to get to a position where we can share those costs with with the client, with the applicant. What I'm not prepared to do is talk about commercially sensitive information, in public forums. So I think there's a slight difference to what you were saying there.
Another way of putting that would be you're not willing to be open and transparent with the decision maker in this inquiry process.
Well, we're not willing to share the information on a public forum here that's being recorded. I'd be more than happy to share the information, with the reporter directly. But, like I say, it's a business decision that we don't think it's appropriate to share commercially sensitive information in a public forum like this.
I think I understand your position. So I want to look more generally at the position of mitigation that the airport currently has and what that looks like going forward. So how much did the airport receive in total from wind farm developers last year under similar arrangements to the one that you want my client to enter into?
Well, we didn't receive any payments that are in a similar form to the form of agreement that your client would be signing, because that's the latest agreement, which I talked about yesterday, which is the annual payment.
Let's broaden it out then slightly. How much money did the airport receive from wind farm developers generally under any agreement that you have related to mitigation?
I think it was about £4.4 million.
Last year?
Do you mean the latest reported accounts?
No, we're going to come on to the accounts in a moment, but there's a bit of a gap. Obviously, you've not reported yet for the previous year. I'm just wondering, how much did you get last year?
Well, we haven't reported any of our figures yet, so therefore that's not something that we will again talk about in the public domain, because our accounts haven't been audited and published.
Okay. Are you willing to give a broad indication of whether it's similar to the sum that you received the previous year?
Well, it's absolutely not similar. To be honest, I can't tell you exactly how much it is, and I wouldn't be telling you how much it is exactly anyway, because, like I say, the accounts aren't audited and they aren't published. But it's nowhere in the region of the figure the year before.
And rather than asking a question about how much you've received, then I suppose one way of looking at it is how much do you expect to receive from wind farm developers in the current financial year going forward?
Well, again, it's not something that we're going to talk about in a public forum. We're not going to talk about our current financial year at I'm really struggling to understand why this is relevant.
Okay. What I would like to try and understand is how much mitigation and comfort towards risk does the airport have on an ongoing basis as things stand at the moment?
Well, be very clear on our tolerance for risk, and we don't have any tolerance for risk that comes as a result of somebody else's commercial activities. These are not risks that come as a result of us, operating an airport and having aviation interests. They come as a result of the applicant's commercial activities. And I think all businesses, well, even when you're considering risk that comes as a result of your own activities, most businesses would take a prudent view. The applicant themselves, I think, declares that they take a prudent view of risks, and actually they refer to that in in their latest published accounts, which I think we have lodged. I think it's GPA document GPA 53. If we want to have a look at that, Mr. McLeod.
It's your evidence, Ms. Ms. Kilpatrick. Do you want to look at that document?
Well, yes, that would be good. Thank you.
So which was that? GPA?
GPA 50. And it's page 3, but I think it might be page 5 on the electronic version.
Yes, I see that. Yes.
And the heading is Principal Risks and Uncertainties. And it says, in order to deliver its strategy, Scottish Power, and therefore the company, are required to conduct business in a manner benefiting customers through balancing cost and risk, whilst delivering shareholder value and protecting Scottish Power's performance and reputation by prudently managing the risks inherent in the business. So the applicant states that it takes a prudent approach when managing risks that are inherent to its own business. So these are risks that occur in the course of it carrying out its own business activities. Now, of course, the airport has inherent risks that come as a result of it operating an airport and having aviation interests. But we're talking about risk here that is imposed on the airport. It is not inherent risk. It is imposed on the airport as a direct result of the applicant's commercial interest. So I think it's perfectly reasonable that we take a very prudent approach to risk that doesn't come as a result of our own activities. And like I say, it's perfectly in line with the applicant's view of risk that comes as a result of its own business interest.
Yes, well, a couple of points arising from that, and I think you've acknowledged it. First, Scottish Power operates within a regulatory framework that is different to yours. Do you accept that?
Well, we are also heavily regulated in different ways, yes.
Indeed you are, and we'll come to look at that in due course. But do you also accept that the interaction of land uses, which is really what this is about, the interaction of the airport and a proposed wind farm, is regulated in a different way through the Electricity Act and the planning process?
Yes.
Have you got the circular that I referred you to earlier on yet?
Yes, Ms. Cornelius brought that.
So, sir, for reference, that's CD 11.2.
Yeah.
Have you seen this document before, Ms. Kilpatrick?
No, I haven't.
Okay. Well, let's take it slowly then. So, the introduction on page 1, the circular and the accompanying annex sets out government policy on use of conditions in planning permissions. and then it goes on to explain what it's updated. You see paragraph 2, which sets out Scottish Government's general policy. Conditions imposed on grant of planning permission can enable many development proposals to proceed where it would otherwise have been necessary to refuse planning permission. So that, would you accept as a recognition that a condition can be used to mitigate an impact or a risk arising from a development?
Sir, I hesitate to intervene at this point, but I'm a bit concerned about where Mr MacLeod is going with this line of examination. Miss Kilpatrick has said she's not familiar with this document, and I would suggest, sir, that there's no reason for her to be familiar with it. We're now getting into a matter, I fear, which is actually more for submissions made by the lawyers involved in the process rather than something which a witness of fact can be expected to speak to. So I table an objection to this line, sir.
Mr MacLeod?
Well, it will undoubtedly be a matter of submission in due course, sir, but this witness has given evidence to the inquiry about what an appropriate basis for the condition and GPA's mitigation services will be. And what I wanted to give her an opportunity to consider is what Scottish Government policy says on the issue.
Yeah, I do think this possibly does get to the heart of the matter. So I would like to hear Ms Kilpatrick's views on it, but I do obviously take on board that she isn't a professional planner, and I wouldn't expect her to give or have that background or give detailed professional planning views on it. But I think it would be useful to hear her reaction to some of the points in the circular. So I think I'm happy for the question to proceed. Mr MacLeod.
Thanks, sir.
Thank you, sir. Thank you, sir.
Yes, Ms Kilpatrick. So the question that I put to you was, if you read the first sentence of paragraph 2, conditions imposed on a grant planning permission can enable many development proposals to proceed where it would otherwise have been necessary to refuse planning permission. That is a recognition that a condition can be used to mitigate an unacceptable impact from a development to allow it to proceed, isn't it?
Well, as I think Mr Brown's already said, I'm not a professional planner. I don't have a planning background, but you know, I would read it, and I think that's a reasonable interpretation.
That's very fair, thank you. You'll then see that it goes on to say, while the power to impose planning conditions is very wide, it needs to be exercised in a manner which is fair, reasonable, and practicable. And I'm not actually putting any question to you on that. I'm simply reading it to give you the opportunity to consider the context for what comes next. Because Scottish Government policy then goes on to say planning conditions should only be imposed where they are necessary, relevant to planning, relevant to the development to be permitted, enforceable, precise, reasonable in all other respects. And you'll note the importance, the great importance that the Secretary of State attaches to these criteria being met. So there's an effective basis for the control and regulation of development, which doesn't place unreasonable or unjustified burdens on applicants and their successors in title. So just picking up that final point there, doesn't place unreasonable or unjustified burdens on applicants. That suggests there is a need for any burdens to be justified, doesn't it?
Yep.
And in order for that justification to occur, there really needs to be quantification of what the burden will be.
Yes. Yes.
But you're not willing to give that to this inquiry.
I'm not willing to talk about the commercial agreement in the public forum, but as I said, we have been exceptionally keen to provide your applicant, the applicant, with full details of the commercial terms, including the charges, and to then follow that up with a discussion where we talk about what we perceive the risks and costs to be and our justification for said charges. That process, unfortunately, has never happened, and it is not appropriate that that takes place at a public inquiry. So, you know, it's not through lack of trying that your applicant does not have sight of the, the agreement and the terms, and and to be fair, has not had any interest in engaging with us on the wind farm mitigation agreement at all. So, I don't think it's fair to say that. Well, I certainly don't think you can make a judgment that the agreement is unreasonable or unjustified, because we've not yet had the opportunity to have that conversation with the applicant.
Can I put it a different way to you? How is the reporter to judge whether your demands are reasonable or justified if you're not willing to place any evidence before this inquiry as to the basis of the charging or what the money will be spent on?
Well, as I've already said, I would be more than happy to provide that information directly to the reporter. What I'm not prepared to do is share that at a a public forum now here today. And I don't think that should be any surprise to anybody here. These are commercially sensitive areas that we're talking about, and it's appropriate that we have those conversations with the developer face to face.
I understand that's your position, and that will be a matter for submission later. Keep the circular to hand if you would, because we will come back to it. But I wanted to move on to talk about Prestwick's accounts, that's in document APP 3.5. And are you working from a hard copy or an electronic copy, Mr.
Hard copy.
Hard, right, okay. So it's split into, I think there's maybe 4 sets of accounts, three possibly. The first one that I wanted to look at was 2017 accounts. And for those working with the electronic copy, I think it's page 70.
What page am I looking at, Mr.
Page 21, please. I'll just make sure we're actually looking at the correct ones. At the top of that page, it should say 31st March 2018.
No, I've got 31st March 2017. I'm looking at page 21.
My apologies. Let's leave the 2017 accounts because they're not actually particularly clear for the point that I wanted to address. Let's move on to the 2018 ones. And it's page 21 of those. So that is page 70 of the electronic copy, I hope. Have you got that one?
Yeah.
Yeah, I'll just check the reporter's got that one as well. It's page 21. It's headed Accounting Policies Continued. And it's 31st March 2018.
Yes, I have that.
Got that. Thank you, sir. Sorry about that. What I wanted to look at was in the section 3, group operating loss, about 4 lines down, you'll see assets under construction bracket radar. And what we can see there is that in 2017, the airport spent £735,000 on the radar upgrade, that's presumably the Terma and other bits of the WIN, the the radar system that you are in the process of commissioning now.
Are you asking me a question or are you stating that?
I am asking you a question just to make sure that I'm correct in that assumption.
I can't give you a definite answer on that, sorry.
Okay. Were you in 2018, 17, 18, are you aware of any other radar assets that were under construction?
No, but that might, you know, that's only my knowledge. I mean, bear in mind, I wasn't with the business at this point in time.
Okay. Well, we'll proceed on the basis of the evidence that we've got, which is that in 2017, £735,000 was spent on assets under construction radar. So far, so good.
And we'll work on that basis, yeah.
Yeah. And then in 2018, we can see that 1.66 million was spent on the same item of expenditure.
Yep.
What we can then see, 2 lines down, is a line which reads less wind farm radar mitigation income recognised. And you'll see that the figures are deducted, so the 1.66 for 2018 and the 735 for 2017. And that suggests, doesn't it, that these are, or this did relate to the Terma installation, and that the money for that radar upgrade was coming from the wind farm developers?
Yes, those MA1 agreements, the first agreements, were structured as capital contributions, yeah.
Yes. And do you know whether those were the only wind farm mitigation sums received in those years? It looks as if there was cost recovery at that point in time, but what I'm wondering is, was there more money that came in from wind farmers at that point in time?
I can say with confidence that, with reasonable confidence, that the 2017 number, I think, is correct as it's stated here, but I can't tell you for fact about 2018, although it does look like that is correct as the total income. Although, again, you're asking me to recall financial information here, and you know, I'm not aware that there was anything in addition to that that stated
But that's fine. I wanted then to move on to the 2019 accounts and to page 24 of those, which in the electronic copy should be page 113.
I've got that.
The reporter's got that as well. Good. So again, this is really the equivalent page, I think, from the previous set of accounts. And again, we can see about 4 lines down, assets under construction radar, and you can see that 1.66 million that we saw in the previous accounts for 2018. We can see the wind farm mitigation income recognised coming off. I'm interested in the 2019 though, for that row. Assets under construction radar, there's nothing there. So that suggests that by that stage, the cost of the radar had been fully met?
Well, I'm not a chartered accountant, and I didn't prepare these, you know, these accounts. If you are suggesting that the total capital investment of the new surveillance system equates to 1.66 million, and 0.735 million, then the answer to that is absolutely not. You know, it was far greater than that. But you know, like I say, I'm not a chartered accountant and I didn't prepare these accounts. So if your question is about the cost of the radar, then the answer to that is it is not 1.66 million plus £735,000.
And what was the cost then?
Well, I mean, I think the applicant states a comparable cost for. Well, I think Miss Mackenzie referred to it as Terma, but it's obviously much more than Terma. Surveillance suite, and I think she used Teesside as an example, about £3.5 million.
So sorry, excuse me. So I'm slightly unclear. Are you saying that the total cost was 3.5 million?
No, I'm saying that's a reasonable benchmark to use. Again, I'm not going to, you know, talk about the cost of our equipment again in a public forum, but it's a reasonable, you know, it's a reasonable benchmark to use. The other thing that I did mention yesterday as well, though, was that the capital investment in the current surveillance system is not yet complete, in that the system that we have acquired does not give us the full range that the current S511 gives us, because the technology wasn't available at the time that we acquired the system. That additional range capability is now available, and it will require an additional significant capital expenditure, which we will be making in the very near future.
Yes, I was interested in that. That's your evidence and examination in chief yesterday is the first time that that's been mentioned. You're presumably aware of duties of prior disclosure to the inquiry. How long have you known about that position?
What position particularly?
Well, the position that you explained yesterday, which that there is further capital investment required in the term.
Well, it's capital investment that's required to take us back to the capability that we have with the current S511 radar. So it's investment that we are going to need to make in order to get the range back to that it was before.
But I thought and we may be straying into technical detail here, and please tell me if we are, but I thought the airport's position was that you were going to have a combined system where the Terma would do some of it, the existing 5111 would do some of it. Does that not provide you with the operational coverage you need?
Well, you know, as you say, I'm not a technical expert, and Mr. Fido will speak to you shortly, and I'm sure he can answer questions that are of a technical nature. But I suppose from a layperson's perspective, and again, Mr. Fido will correct me if I'm wrong here, but the S511, you know, isn't going to be in place forever. So, you know, at some point that range disappears if it's not replaced.
Yes. It needs to be replaced regardless of whether this wind farm goes ahead, doesn't it?
Yeah, the point I'm making is that our investment in the Terma system is not yet complete. That's the point I'm making.
I'll put the question to you again. Your expansion of the Terma, the further capital investment that you need to make in the Terma, needs to happen regardless of whether this wind farm proceeds, doesn't it?
Well, we need range from a radar, but you know, but what we've acquired is a wind farm tolerant radar in order to deal with some of the wind farms that are already in our environment. So as an airport, yes, we do need, you know, a surveillance system, of course we do. But to run our own business, we don't need a wind farm tolerant radar, we need a radar.
I'll try a third time, and a simple yes or no if you could, please. Your capital investment in an expansion of the Terma radar needs to happen whether the Clauchrie wind farm proceeds or not.
Oh yes, yeah, that's true.
Coming back then to the the question of costs and costs that the airport has incurred so far. Excuse me. Although you're not keen to give us an exact figure, I think what you've said to the reporter is that the figure of 3.5 million is a reasonable benchmark to use in this case.
Yes, that's correct.
Yes.
And would you be willing to give a further reasonable benchmark for what additional costs it would take to get the wind farm commissioned?
Sorry, what do you mean by
the radar commissioned. You've spent, in broad terms, £3.5 million or thereabouts has been spent to date. You said,
sorry. When you say spent, you mean that's the capital expenditure. You're not at all recognising the operational expenditure in that, are you?
well, I don't know. I'm interested in your evidence. I mean, the figures, with no disrespect intended, the figures are somewhat opaque at the moment. And what I'm trying to understand is, what does the airport say the total cost of installing the Terma will be up to the point when it's commissioned?
Well, again, Mr. McLeod, I think the avenue we're going down here is that, which is very much the applicant's position, is that the cost of providing mitigation is limited to the cost of installing initial technology that is radar tolerant. And from that point onwards, you know, the applicant's position is that the airport is not subject to any additional costs or any risks, you know, as it undertakes to mitigate the wind farm for 25 years, 30 years, possibly in perpetuity. So you're trying to quantify an initial investment in a technology and limiting that investment actually to capex and propose that those are the only costs that the airport will incur as it undertakes mitigation for the long term. So I would say that bears no relevance to the position that the airport holds. That, you know, yes, there are initial costs, but there are costs and risks that the airport is exposed to in the long term. Now, risks, so we cannot have an exercise where we are totting up costs that have occurred now and stating that those will be the costs that the airport will incur, those were the only costs that the airport will incur for the lifetime of the wind farm, because that just is not reality. I explained that yesterday. There are lots of costs and risks that come as a direct result of wind farm developments in the environment. They are additional costs over and above what the airport would incur in carrying out its business. So you know, that's what the mitigation agreement is there for. That's, you know, what the charges reflect. It's about cost now and cost and risk in the future.
I understand your position, and you've repeated it a number of times, and we will come back to some of the ongoing costs and risks later, I can assure you. What I'm trying to understand at this point in time is what you say the airport has incurred, both from an operational and a capital cost perspective, in taking the Terma radar from inception to commissioning. Are you able to give me a straight answer to that, please?
Well, no, I can't give you an exact figure.
Broad indication would be fine.
Well, you know, I'll restate my position here. We've talked about the capital expenditure that's already...
Cornelius, sorry, I keep calling you Miss Cornelius because Miss Cornelius' name is on the screen. Miss Kilpatrick, I don't want to hear your general position again. I've asked you a specific question. Are you willing to give the reporter a broad indication of the capital and operational expenditure that the airport will have incurred by the time that the Terma wind farm, Terma radar is commissioned? Yes or no?
Well, it will be, you know, well in excess of £4 million, and that's without any further upgrades.
So in excess of 4, but less than 5.
Well, I said, well, I haven't got figures sat in front of me here, you know, Mr. McLeod. You're asking me for a broad position and then you're trying to, you pin that down. So I'm saying it's going to be well in excess of 4. But I haven't got.
Well in excess of 4 could be 40, or it could be 4.9. And I'm just trying to, I'm trying to be fair to you here, Ms. Kilpatrick. Your evidence is that it's well in excess of 4. I'm simply trying to quantify or clarify that. Again, in broad terms, we're talking about round about 5 million at worst, yes?
Well, we'll work on that basis, Mr. McLeod. That's fine.
Okay. Can we then look at what the airport has received to date in terms of contributions? In 2016-17, I think we're agreed the airport received £735,000. That's from your company accounts.
Yeah.
In 2018, the airport received £1.66 million.
Yeah.
In 2019, a figure we've not looked at yet, but that's on page 24 of the 2019 accounts. The airport received 1.3 million in what's described as wind farm radar mitigation income. Yeah.
Yeah.
That all went towards Terma. Oh, well, the upgrade to the radar system. Yeah.
Yeah.
And then if you turn to page 11 of the 2020 accounts, and I think that's, sorry, I was just looking for the page number there, page 157 of the electronic version. You'll see a figure of, in fact, I beg your pardon, it's probably better if we go to page 25 first of all in those annual accounts. And that is page 157 in the electronic version. So have you got page 25 there, Ms. Kilpatrick?
Yes, I have.
Yeah. And I've gone here just for orientation because we can see 2019 figure is 1.3 million. That's the figure that we saw from before, isn't it? That's the what was described as the wind farm radar mitigation income of 1.3.
Yeah.
And then in the same column, same row, I beg your pardon, we can see 4.452 million as income relating to the provision of specialist aviation services. What are those services?
Well, this is income that has come from our wind farm mitigation agreement. So this, you know, the services is probably not the best way to describe it, and probably doesn't do it due justice. You know, we are undertaking as a business the cost and the risks of mitigating wind farms for the lifetime of the wind farm. So that income, you know, is to provide for the costs and the risks that we will endure for 25 or 30 years in guaranteeing wind farm mitigation.
Okay. But to be absolutely clear, there's no quibble, there's no question that 4.4 million is from your wind farm mitigation services agreement.
No, we didn't do that yesterday.
Okay. So by my calculation, if we add up those various figures, the 4.4, the 1.3, the 1.6, and the 0.735, I think we get to about £8.2 million that you had received by 31st March 2020.
That's correct.
So looking at the costs that you will have incurred in commissioning Terma, you've got a £3.2 million surplus working on those sort of broad brush principles we talked about previously.
Well, no, because like I say, we will be making a further investment in Terma in order to extend the range to the range that we have from the current radar. So that isn't the limited extent of the investment.
What is the cost of that extension?
I can't tell you the exact figure, but it's going to be, it's going to be probably £750,000, maybe a bit more than that.
Okay, let's call it one just for ease of rounding. So by the time that you've spent another £1 million on extending the radar, you will still have £2.2 million in the bank from wind farm mitigation agreements. Yes?
On that basis, yeah.
And that was the position as at 31st March 2020. You're not willing to tell us what you received this financial year, or what you're likely to receive on an ongoing basis.
Well, the income for wind farms will be transparent when our accounts are published.
Yeah. Can we agree that it will not be less than 4.4 million from 2020?
Sorry, what? It will not be less than 4 million, did you say?
Yes.
It will be significantly less than 4. Sorry, are you suggesting that in our next published accounts, our income from wind farms will be as much as £4.4 million? Is that what you're suggesting?
Well, I'm asking you, is that fair?
It will be, nowhere in the region of £4.4 million in our next accounts. And like I say, I'm not going to tell you the details of our accounts that have not yet been audited and have not yet been published, but the quantum will be nowhere in the region of the figure that was received in the 2020 accounts.
Okay. The money that you've received to date, has that been ring-fenced for the upgrade to Terma that you've told us about over the last day or so?
Yeah, I mean, we've due to, and again, like I say, I'm not a chartered accountant, but due to accounting policy, we've had to receipt that income, but we recognise that the exposure to cost and risk will endure for 25 or 30 years. So yes, income has been received, but it has not left the business, so to speak. So yes, the money is available for the costs that we will incur as a result of the upgrades that are required now, but also the costs and exposure to risk that we will have for the next 25 years.
And those costs and risks, would include things like the need to replace the thermoradar in due course.
Well, no. I mean, I'm talking about risks that come as a direct result of us having to mitigate wind farms in the environment, these risks that are imposed on us. I'm not talking about costs that come as a result of us conducting our own standard normal business. These are additional costs. So as you've quite rightly said, we're an airport and we need a surveillance system, which we do, and we would then need to replace that surveillance system on, you know, a life cycle basis, which we believe will be 10 to 15 years. What we now have to do is we have to replace that radar with a technology that is wind farm tolerant. So, you know, we are not approaching that procurement in the way that we would, you know, approach that procurement if we didn't have wind farms in our environment, and that brings risk. And that was the point I made yesterday. So yes, we would replace the radar because we would need to replace the radar, but we wouldn't necessarily have to replace it with a radar that had the capabilities that we need currently because of the wind farms in the environment.
Well, when the airport comes to replace its radar system, it will have to comply with whatever legislative and policy guidance applies at that point in time. Would you agree?
Yep.
And that's a matter which is many, many years down the line, yes?
Yes.
Do you expect that wind farms will remain a recognised technology for the generation of electricity going forward?
I imagine, yes. It's a reasonable assumption.
Would you expect, therefore, that any policy or legislative requirements related to radars would require radar systems to be wind farm tolerant?
Well, I'm not the CAA, so I can't, can't comment on that.
Well, no, but you're talked about allocation of risk and who's responsible for what. I'm simply asking for your thoughts as an experienced commercial director of what the legislative and policy risks might be going forward. Do you think that in 15 to 20 years' time, it's likely that the CAA will mandate that radar systems must be wind farm tolerant?
It could do, yeah.
Think it's likely?
Well, I mean, the DFT's position currently on mitigation and the costs that come as a result of mitigation is quite clear, and the DFT's position is that the costs of the radar cost of mitigation should be borne by the developer who stands to profit commercially from the activity. So I don't know what the CAA's position will be in 15 years' time.
Let's come back to the circular that we looked at earlier on, the circular on conditions. And again, appreciate I'm putting this to you for the first time, but I just wanted to talk through a couple of paragraphs with you. And again, I recognise you're not a planning expert, so your evidence is seen in that context. Paragraph 82, please, which you'll find on the pages aren't numbered, but electronic page 23 for anybody working from that. You have that, sir?
Yes, I do.
You do, okay. So paragraph 82 is, we can see from the heading, related to conditions requiring a financial or other consideration for the grant of permission. And the first sentence sets out the general proposition that no payment of money or any other consideration can be required when granting a permission or any other kind of consent required by statute, except where there is specific statutory authority. Now, the second sentence, there's part which is not relevant, which talks about, it gives an example about cessation of land for road improvements. That's not really relevant, but the bit that may be relevant, conditions requiring the developer to contribute money towards the provision of facilities not directly related to the proposed development should accordingly not be attached to planning permissions. Now, just thinking about that sentence, what facilities is it that you say are directly related to the Clauchrie wind farm that need to be provided?
Well, I think I was quite clear in what I said yesterday. There are some costs that we know, will happen. So there are things that happen, initially at the start of the process when the wind farm is erected, which are covered off in the safeguarding process that Mr. Thompson's talked about. And then there are some ongoing costs, and there's exposure to long-term risk that will come as a direct result of the wind farm development. I talked about EC yesterday, and if that's mandated, if we're talking about policy changes here, and that as a direct result of the Clauchrie development, our implementation costs of that, would be higher. Talked about the capacity that wind farms impose on radars that the ATS then has to, replace and is not available for its core business. There are various things that I've talked about. I've talked about the risks of having to provide wind farm tolerant radar capability and what might be available in 15 years' time, what might be available in 30 years' time. And I take your point that things could change, but you seem to be suggesting that things only change favourably, and that's just not the way things work. So there are costs and risks that come as a result of the wind farm being in the environment, and therefore the airport needs to be compensated to take on board that risk and cost that's been imposed on it.
So you need to be compensated, and that's compensated at a level set by.
Well, I mean, if we're going to get into the semantics of words, maybe, and you may be going to go somewhere with the word compensate. I think what I've been very clear about here is that the airport is exposed to additional cost, and it is exposed to, significant risks that will have financial consequences. And it is not reasonable to expect that the airport absorbs those things, because were it not for the wind farm, those additional costs and risk exposure would not exist.
Can I just pick up on
compensation, or whatever words we use for it, but it is not reasonable for the airport to bear those.
In your opinion, and I understand that is your opinion. Can I just pick up one point? We'll come back to some of the other points in a moment or two, but just on the question of electronic conspicuity and your evidence yesterday, which you've repeated today, I have you noted as saying electronic conspicuity, Ms. Mackenzie believes it will be mandated. If it does, we'll have to expand what we'll have to do over and above what we normally have to do. Turbines have some residual issues on SSR, resulting in additional OPEX. Now, you'll gather from what I read out there that I didn't take a full note of what you've said, because we can go back and watch that. But generally speaking, I'm interested in that last part. You said turbines have some residual issues on SSR that would result in additional operational expenditure. Is that correct? Is that what your evidence was?
I think broadly, obviously, I can't remember exactly what I said, but that sounds broadly in line with what I said. And I think I also said that Mr. Fido would be able to give obviously a technical explanation of that. I'm not a technical witness here. I take advice from our technical experts, and Mr. Fido will talk to that in more detail when you speak to him shortly.
Okay. Well, I wanted to put something to you from Mr. Fido's inquiry report. I'll probably put it to him as well. You don't necessarily need to get a copy of it available. I'll read to you exactly what it says, but it's Mr. If you want to have a look at it, it's Mr. Fido's expert report. It's page 20 of 40, and it's in section 4.2.1, general, and that's then divided into 5 subparagraphs, and it's subparagraph 4. Just make sure everybody's got a note of that. 4.2.1 bracket 4. And what Mr. Fido says on the subject of SSR is SSR is not impacted by the Clauchrie wind farm and will not be considered, other than to explain later in my report how the technologies differ in operation. So, accepting you're not an expert on the matter, it appears your expert doesn't think this wind farm would have any impact on SSR.
Well, I'm not a technical witness, as you just said, but I think, and Mr. Fido will clearly talk to this, but I think the situation you are proposing is slightly different to that I talked to you today. Again, I'll let Mr. Fido, explain in detail, but we were talking about EC being mandated and the impact that the wind farms would have on the implementation of EC. And I'm guessing, I mean, I haven't got Mr. Fido, well, I've just got Mr. Fido's report in front of me, but I haven't got the paragraph in front of me that you referred to, but I'm assuming he's talking about that in the current environment.
Okay.
But you can ask
well,
it a question.
We can come back to Mr. Fido on that. So, but as far as the cost, well, as far as any costs associated with the implementation of EC is concerned, that is surely a discussion for the aviation industry, the Civil Aviation Authority, and the government to have in due course, isn't it?
In what respect? Who pays for
Well,
it? Who pays for it?
Yes.
No, the point I'm making is, or the point I was trying to make yesterday, is that there are risks, and I was trying to articulate what some of those risks can be, and some of the risks that could be or come to fruition in the medium term, because we clearly don't know what's going to happen. Well, we don't know what's going to happen in 2 years' time, but it's very difficult to anticipate what will happen in 20 years' time, or 30 or 40 years' time. The point I was making was, change happens, it can have an impact on the operation. If EC is mandated, as Miss Mackenzie has mentioned, then yes, the airport would need to implement that, and it would have a responsibility to do that as part of its core business. The point that was being made was that we would have to do more than we would ordinarily have to do in an implementation of EC because of the wind farms in the environment. So yes, we would have to implement EC, but because the wind farms are there, that implementation would be bigger and it would cost more.
Much more, do you think?
Well, I mean, I think you need to speak to Mr. Fido to really, have a better understanding of the technical, rationale behind that statement.
The technical rationale behind your evidence?
No. Well, I'm not giving technical evidence. I put forward some potential risk scenarios, and I caveated those yesterday by saying that Mr. Fido would be able to talk about the technical details of those, because I clearly, I'm not a technical witness here, and I take advice from, our technical experts.
Okay. Can we look at that issue very briefly in general terms then? Your precognition says, as I understand it, in essence, your precognition says you're not looking for mitigation on a cost recovery basis. It's a commercial negotiation. That's correct, isn't it?
Well, we've covered the cost recovery basis here, I think, a few times. A big part of cost, and I mentioned this yesterday when I talked about risks and things that could happen as a direct result of wind farms. And that's not just about, potentially buying things or having ongoing OPEX obligations with third parties. Resource is a big part of this. If we make changes to our systems that come as a direct result of a wind farm, then, we have a full safety case procedure to go through, and that's very resource intensive and resources operational expenditure. And the point that I've made on a couple of occasions now is that it is not reasonable to expect that the airport provides that resource on a cost recovery basis, i.e., in the example we used yesterday, Mr. Thompson's salary, on a daily equivalent rates, and essentially charging that back. We put a value on our employees and our employees' time. So if we direct them to do something, we will have a value on that that's over and above the cost to the business, i.e. their salary.
But can we just be clear, because I was going to come on to resources shortly, but we'll just deal with it now. Can we just be clear on what resource implications you say we're talking about here? And just to put that in context, put a question to you. Is it your understanding that once Terma has been commissioned and becomes operational, there is very limited resource required on an ongoing basis to manage that radar system?
Well, you're talking about a piece of equipment, and we're talking about maintaining our license. And those are two very, very different things. We have, our use of the word maintenance is quite different to the one that I think you're referring to here. So I think you're talking about maintenance of the system. So a Terma engineer turning up on a periodic basis to make sure the radar works. Well, that's not what we would call maintenance. We have safety cases to maintain the live documents. And again, Mr. Thompson spoke to that. I am not, the accountable manager for safety, nor do I speak on that subject. But maintenance for us is maintenance of our overall operating systems, maintaining our license by meeting our obligations.
Yeah. Well, we're going to come on to what maintenance does mean and what the CAA say maintenance means. But just so we're clear, when you talk about the level of resource that's required, can you just explain to the inquiry what we are actually talking about?
But in what regard?
Well, your evidence is that because of the presence of wind farms and this wind farm, there will be an additional level of resource requirement going forward, post-Terma being commissioned. And I'm simply trying to understand at this stage what that additional resource is. What do you say that additional resource requirement is?
Well, I mean, again, we're having to make decisions now, or we're having to make judgments now for the next 25 or 30 years. We're having to look at what the obligations, the long-term obligations on the business are going to be as a result of mitigating wind farms. So, it is not an exact science. As I've already said, risk cannot be quantified. So, we are taking a view on what the financial implications and the level of risk are that come as a result of mitigating wind farms. And we will put a value on that we will, as I've said on numerous occasions, would be quite happy to sit down and talk to the applicant about and share details of, along with the proposed costs. But I don't think it's particularly useful, although I'm sure you would disagree, in trying to pinpoint certain costs here that are in the here and now. And that's the point I'm trying to make. We're talking about obligations that endure for a long time. There is huge risk here. You've acknowledged that change happens. So we've accepted that concept, and we've accepted the concept that when change happens in our operating environment, it can have an impact on us. So, surely it's a contradiction in terms to say that change happens, it can have an impact on your business, but it's not a risk. Because by definition, that is a risk. And that risk comes as a result of the applicant's commercial activities. Those risks are not born as a result of the airport's commercial activities. So we have to take a long-term view of cost and risk and make an assessment of what we think that is. And we always have to make sure that we have a responsibility to our shareholder, so that the business is not financially exposed in 10 or 15 or 20 years' time. And that has to be acceptable to both our board and the shareholder.
Mr. MacLeod, there's a suitable break coming up. If you'd like to think about a suitable time to break for a short comfort break.
Yeah, that sounds sensible, sir. If I could maybe just have another 5 minutes or so. I want to put that one question that I just put again, and then I want to come back and have a quick look at the circular, and then we'll be moving on to a different topic. So that might be an appropriate point to break at that stage, if that's okay with you. An appropriate point.
Oh, I don't know if I'm losing signal.
Yeah, I think
the reporter's connection's just dropped out. I'll contact him to see what his situation is.
Callum, I'm not sure if you can hear me at the moment, but I'm just wondering whether it's as well to take maybe a 10-minute break at this stage, and that lets Mr. Hall sort out his connection issues.
Can you ask him?
I think that's probably sensible, Callum. Certainly no objection from the airport's perspective on that suggestion.
Executive decision for that suggestion.
Sorry, I've just been on the phone with the reporter and he says he's joined back in, I think. Steve, can you hear me in WebEx?
Just going to keep it general.
Sorry, I didn't quite catch that. Were you suggesting a break for 10 minutes? Just 10 minutes.
Yeah, I was suggesting that if Mr. Hall's still having connection difficulties, then maybe we just break for 10 minutes now, and then that lets him sort that out, and we can come back after that.
Yeah, that's fine with me. Thanks for that.
Okay. The other thing, just before we break, then, Mr. MacLeod, is you mentioned that the name Amy Cornelius is appearing underneath Miss Kilpatrick, so we will go into the room and we'll get that changed. But I assure you nothing.
I think it's I think it's disappeared now. I think we're okay now, actually.
No, it still comes up.
Okay.
Okay.
Thanks.
Right. Thank you.
11:40, Callum.
Yep, 11:40 is fine. Thanks.
Hi, Callum. Can you hear me?
Hi, Steve. Yeah, can hear you fine.
Yeah. I got a little message coming up saying that the laptop was reconnecting. So it must have, I think it dropped out for a moment, and then it must have somehow.
Yeah, I think it could have been the VPN, the Scots VPN, because Fiona Manson in our team chat just at the same time you dropped out said she'd lost connection for a split second, but she's
Right.
back in now, so hopefully that's thing resolved.
Okay, right, fine. Well, hopefully I didn't miss too much. Okay, right. So back at 11:40.
Right, thanks, Steve.
Thanks, Callum. Cheers. Hello, am I back with you?
You are, sir. Can you hear me okay?
Yes, I can. I think I just dropped out for a second there. I think it happened to other people on the Scottish Government network as well. So I came back and I could hear and see what you were saying, because you couldn't hear me. So I've come out of the meeting and come back in, and that seems to have worked. So I think I dropped out just after our discussion about having a break, actually. But it wasn't deliberate, I promise. So if you can recall where you were at that stage, Mr. McLeod, we'll just rewind to there, please.
Certainly, sir. So just before the break, I'd asked Ms. Kilpatrick a question about resources and what she expected the resources would be going forward. I really just wanted to put that question again. What do you expect the resources going forward associated with wind farms will be?
Well, I think I've answered that question, Mr. McLeod. We are taking a long-term view of what the costs and risks are going to be for the business under its obligations to mitigate wind farms for 25, 30 years, potentially in perpetuity. And we have to put a value on all of those elements on the basis that this is imposed risk that does not come as a result of our activities. So we've put a value on that. That translates into the mitigation agreement, and we'd be more than happy to share that agreement with the applicant and have a discussion about the costs and our justification of those costs in a commercial environment. So
I'm sure it's my fault, Ms. Kilpatrick, in terms of the way that I've asked the question or my understanding of your answer, but I don't understand your answer. What I'm trying to understand, I'm not actually asking about costs at this stage. I'm simply asking about what level of additional resource do you say will be required because of wind farms in the future?
Well, needless to say, we think that there will be significant resource required over the next 30 years as a direct result of having wind farms in the environment. And I've not got a figure to give you here and now in the inquiry as to what that is, because I think we're back to this scenario where we're trying to piece together all of the costs that add up to the service charge. And I'll come back to my previous answer. As a business, we have to weigh up lots of things. We are talking about long-term obligations, not 5 years, not 10 years. We're talking about 25, 30 years, possibly forever. We're making commitments that will endure far longer than my time at the airport. And in all reality, I could well be dead and buried before some of these turbine blades stop turning. So they are long-term obligations that the business is undertaking, and we're making decisions now about what they will be in the future. And there's a lot of risk. So we have to make a judgment on what that value needs to be. And as I'll say again, we have been very keen to talk to the applicant about the details of the mitigation agreement and to share the full terms and to share the costs. And we have been very keen to then have a conversation with the applicant to discuss that. Now, we are here today at public inquiry because I think it's quite evident that the applicant was not interested in understanding the details of the agreement or having a discussion about that, which is unfortunate. But nonetheless, the time for having those discussions is with the applicant as would normally be expected for a commercial discussion.
Well, the applicant's position, just check, do you not understand that the applicant's position is that no mitigation is required, and that's the reason that there was no need for a wind farm mitigation services agreement?
Yes.
And that position may be very different to other wind farmers with whom you have entered into an agreement, yes?
Yes.
Has anyone ever challenged the airport on the need for mitigation in the first place?
Well, we've not been to a public inquiry before. Is that what you mean? Challenged in that sense?
I suppose my question is more general than that. So you have undertaken a process by which you have objected to this wind farm. My clients have resisted that objection because they don't believe that mitigation is required. Have you been in a situation before where another wind farm developer has said, we do not believe that mitigation is required?
Well, I can't recall conversations to that extent. I mean, we have quite long negotiations with all developers. They're not, there's lots of points that are discussed when we're discussing the.
Remember something as fundamental as somebody saying no mitigation is required, though, yes?
Well, no, I mean, developers will ask us to explain why mitigation is required. So yes, that absolutely does happen. And we would always provide an explanation as to why the mitigation agreement is required and why there is a cost that needs to be borne as a result of that.
Yeah. Okay. I want to come back to the resourcing point one last time, and I'll try it a slightly different way. You've not been able to tell us what the cost of the resourcing would be or the scale of resourcing. Can I simply ask you this? What would these additional resources, these people, what would they actually do that was directly related to wind farms?
Well, I mentioned a few things yesterday, and clearly I will just restate the point that we are talking about an obligation that lasts for 25, 30 years, possibly.
Again, I'm sorry to cut you off, Ms. Kilpatrick. I don't want to really hear that evidence again. You've repeated it a number of times. I'd really quite like a straight answer to my question, which is, you've talked about additional resources being required. What will those people actually do that is related to wind farms? Can you answer that question, please?
Well, and I think what I was trying to say was particularly relevant to that, because I can't tell you exactly what people will be doing directly related to wind farms for the next 30 or 40 years, because we don't have sight of that. That is why it is called risk, because we expect that things will happen and we need to take account of those, but I can't tell you what will happen in 40 years. We have to mitigate that risk on our business. Now, what I did tell you yesterday was that some of the things that we think might be on the horizon in the medium term that would come as a result of wind farms being in the environment could be things like, we mentioned DC, we've touched on that, but I also talked about other degradation to the system that Mr. Fido will talk about. Now, again, I'm not a technical expert, I'm not here to provide technical evidence, and Mr. Fido, I'm sure will talk to that in some detail. But for example, if there was other degradation, which we believe will be the case and will need to be considered and rectified at some point in the medium term, then we would have a scoping out of a project, we would have a tendering exercise to do, we would have acquisition, we would have to then have installation and testing and a safety case to build for something, whatever that may be. And like I say, I'll leave Mr. Fido to talk about the technicals. People would be required to run that whole process. And the point I'm making here is that process is only required because wind farms are in the environment. It's not as a result of us conducting our day-to-day activities. So in answer to your question, I can give you some examples of what they may be in the near future. I can't tell you what they will be in the long term. That's the nature of risk, and that's a judgment that the airport needs to make.
Yes, I heard you mention yesterday the issue of degradation to the radar, and you've said that Mr. Fido is going to talk at length about that. I was slightly surprised about that because I've not really seen anything in the evidence so far. You mentioned issues to do with track availability, I think, yesterday. Is that right?
No, I didn't mention issues through track availability. I just mentioned I mentioned track availability. I think Miss Mackenzie refers to track availability in either a policy statement or her recognition. So it was in reference to that. and I talked about capacity of a radar. The degradation points, like I say, Mr. Fido will talk to. Clearly, as far as I'm aware, things that has been covered in his precognition, but I'm sure if it hasn't, then you will duly note that when you speak to him.
Well, we can come to that with Mr. Fido, but you mentioned Ms. Mackenzie's policy report. You're obviously familiar with the relevant paragraph, but for the reporter's reference, let's just get that. It's paragraph 17 of Ms. Mackenzie's policy report.
You want me to look at that?
It might be as well to sir, yes. I beg your pardon, it's not. It is paragraph 17. Just give me 1 second. Oh, it's Miss Mackenzie's precognition.
Yes. Yeah.
Apologies, sir. So yes, Miss Mackenzie's precognition, she says towards the end of paragraph 17, there are nowhere near as many as 1,000 operational or planned. Actually, sorry, I need to go back 1 sentence. The TS4002 can maintain at least 1,000 internal wind farm tracks while running on modest hardware platform. There are nowhere near as many as 1,000 operational or planned turbines in radar line of sight. The applicant estimates that there are only 500 operational or proposed turbines in radar line of sight of GPA's radar. Accepting that you are not a radar expert, Ms. Kilpatrick, is it your understanding that that evidence is correct from the discussions you've had with your team?
The evidence that Ms. Mackenzie's given in paragraph 17. So which evidence are you asking me is correct?
Yes.
The statement that Ms. Mackenzie is correct. No, that's not my understanding.
What is your understanding?
Well, like you say, I'm not the technical expert, so I don't want to start talking about technical matters here, and you'll be hearing from Mr. Fido shortly. So I think it's best that you address that question to him.
Well, I will, but your evidence to the inquiry is about commercial risk, and in order to understand whether your evidence is accurate, we probably need to understand the basis on which it is built. So what is your understanding of track capacity so far as the soon-to-be commissioned Terma is concerned?
Yeah, so I didn't reference the quantum of the capacity. The point I made was that the radar has a capacity and it's limited, and that various things consume that capacity, including aircraft and birds and the weather and wind farms. And the point being made was that when a wind farm is built, it imposes a capacity requirement on the radar. So I think I used the example of a laptop and a processing capacity of a laptop. It's a bit like putting a big file on your hard drive of your laptop. You've taken that capacity away and that file stays there. So the point I was making was we have to make available a certain level of capacity on our radar to mitigate wind farms. And that capacity is not available to accommodate growth in our core business, which is aviation. Now, the technical details behind that clearly have to be discussed with Mr. Fido, but I didn't refer to the number of tracks that were available or the number of wind farms when I spoke yesterday. I just referred to tracks and the capacity.
Yes, I think you talked about tracks and track capacity. You said that the radar had limited capacity and that when a wind farm was built, there's a required amount of capacity that's used. And what I was trying to understand is, again, except you're not an expert in this field, but in broad terms, what level of capacity do you understand the radar will have once it is commissioned?
Well, I would far rather leave this to Mr. Fido, because I don't think it's as straightforward as maybe has been presented so far, that there is 1,000 tracks and, well, I'm trying to remember what Ms. Mackenzie said now, that there's a
She said
1,000 tracks and, well, she said there's 1,000 tracks that are available for wind farms, and there's only 500 operational or proposed turbines in radar line of sight. So, you know, I'm giving you the layman's interpretation of risk here, that we need to provide capacity for wind farms, and we need to continue to provide that capacity for wind farms for the lifetime of their existence. You really need to address the technical questions about what capacity the radar has in terms of tracks and what consumption wind farms will use, to Mr. Fido, because he's a technical expert in this area.
I understand. Can I put it to you then on a very general basis? As commercial director for the airport, do you have concerns about the available capacity that Terma will have at the point of commissioning?
Well, it's not been commissioned yet, so you know, that's still to be seen. But I don't think we have any concerns at the moment about the capacity, as of now today.
So capacity of the radar is not something the reporter needs to be concerned with at this stage either, is it?
Well, I take a slightly different view, because I think, you know, there's lots being made about the radar being part of the airport's essential infrastructure that it requires to operate its own business, which is aviation. And what we're talking about here is, it's not about whether or not the capacity is available. We're saying that when wind farms are built, they impose a capacity requirement on our radar that is then not available for our own business. And if things play out and our own aviation business grows as we expect it to do, then there will come a point when we will need to invest in additional capacity, and that will be as a direct result of capacity that is on the system being used by wind farms. So, and if that capacity requirement wasn't there, the wind farms weren't there, and the capacity requirement wasn't there, then we would have that available for our own core business.
Okay, we'll return to this issue, no doubt, with the radar experts in due course. I wanted to come back to the circular on conditions, which is CD 11.2, and you may remember we were looking at paragraph 82, and that was the section dealing with conditions requiring a financial or other consideration for the grant of permission. Have you got that one available?
Yep.
Okay, and just check the reporter's got that too. You will see the second sentence. I think we talked about that one, related to facilities, not directly related to the proposed development. I wanted to go on and have a look at the remainder of the paragraph, because it goes on, in fairness. There may be certain circumstances where the general proposition should not apply, and that's the general proposition about financial payments and so on. The appropriateness of conditions involving financial or other considerations is dependent on the particular circumstances of the development for which planning authority intends to grant planning permission, and in particular, whether the proposed conditions satisfy the criteria in paragraph 12. Those are the ones you may remember we looked at way back at the beginning, the 6 tests, reasonable, proportionate, etc. But then it goes on, thus, conditions involving financial considerations but which meet the tests in paragraph 12 need not necessarily be ultra vires. Now, the way that I read that sentence, and see if you agree with me, is it's implicit that a condition that doesn't meet the tests in paragraph 12 requiring financial contributions would be ultra vires, in other words, unlawful.
Well, I'm not a planning expert, Mr. MacLeod, and I've never seen this document before, and I'm not familiar with it. So, you know, I don't really think it's appropriate that I make a comment on this. You've clearly got a view on that, based on what you read, and I'm not sure what else I can add to that. That, you know.
That's fine. We'll leave that point to submissions. I wanted, though, just to look at a couple of points arising from paragraph 12, and really just to get your evidence on how your solution applies in the light of what the circular says. So if you go back, please, to paragraph 12, which is on page 6.
I've got that.
And you'll see that that paragraph 13 then goes on to set out some more policy advice on necessity. You'll see it's headed test need for a condition. And the paragraph says, in considering whether a particular condition is necessary, authorities should ask themselves whether planning permission would have to be refused if that condition were not imposed. If it would not, then the condition needs special and precise justification. And perhaps particularly relevant, planning authorities should avoid imposing conditions through anxiety to impose against every possible contingency, however remote. Now, as I understand your evidence, you're asking the reporter to require my clients to sign up a financial agreement with you, correct?
Well, to sign a mitigation agreement, yes.
Well, that's what you call it, yes. But it's an agreement that requires an ongoing financial payment to the airport.
Yes, that's correct.
And those financial payments, I think on your evidence, are to guard against possible risks that you cannot quantify at this stage.
No, well, nobody can quantify risk. It's not only the airport can't quantify risk, nobody can. We don't know, it's uncertain. That's the nature of it. We have to take a view on the level of risk that we're exposed to as a business in the long term, and put a value on that. So you're right. No, I can't give you an invoice or something that backs up costs that we think we might incur in 30 or 40 years' time.
But you'll see, Ms. Kilpatrick, that the paragraph goes on a couple of lines down to say that as a matter of policy, a condition ought not to be imposed unless there is a definite need for it. Now, what is the definite need in this particular case for a per megawatt payment per year going forward?
Well, it's required because without that payment, the proposal is not acceptable to the airport because it transfers and imposes cost and risk to our business, which comes as a direct result of the developer's activities. So, you know, it's not acceptable to the business or the board that we are obligated to accept something that will, you know, create additional cost and risk exposure to our business.
For better or worse, a number of wind farm developers have signed up to these mitigation agreements that you referred to, which require ongoing financial payments. Yes?
Yes, rather than a lump sum. payment, yes.
Do those financial payments not give you a degree of comfort as to the management of risk going forward?
Well, that's why we have them, yes.
Yes. At what point will the annual payments from wind farm developers reach a level that that no more financial payments will be required? In other words, at what point does the level of risk on one hand versus the amount of money you're receiving on the other to mitigate that risk, at what point does that balance out?
Well, that's again a judgment we have to take, because we have to look at, you know, what we think is will happen in terms of the environment and the number of wind farms that will be built, and we have to look at the risk that we think we're exposed to. And actually, you know, it's not. I think also what you need to consider is that each wind farm that's built then adds to the, you know, adds to the cost and risk as well. So there's a cumulative effect that they bring. It's not, you know, it's not a level amount of cost and risk that is there if there's 2 wind farms or 10 wind farms or 15 wind farms. They all add cumulatively to that cost and risk burden.
Let's take a hypothetical wind farm developer who has signed up to one of these agreements. They pay you an annual sum, and you're obviously not willing to disclose what that is. If you don't use all the money you receive in 1 year from that wind farm developer for mitigating risk, do you pay it back to them?
No, but equally, if we then get another year where we spend a lot more than we'd forecast, we don't go and ask them for more money.
Yeah, but
That's
you see the point.
That's the risk that the airport takes. So the airport takes a view on that exposure to risk and cost, and the developer gets certainty that that's the cost, and the airport then takes the risk. So it could be more than that some years, it could be less than that some years. And you would expect it to be like that. You wouldn't expect it to be a straight line trajectory of cost.
Well, let's suppose that you undertake no mitigation. Once term is up and running, and once you've extended it using the money that you've already got in the bank, let's suppose that Terma operates as it should do, and you don't really need to do anything on an ongoing operational basis for the next 10 years. You will receive an annual income from wind farm developers for doing nothing in reality.
Well, I mean, that's a lovely scenario that you've just painted there, Mr. McLeod, where the future has no risk and nothing changes. And it also doesn't, you know, you're not acknowledging some of the things that I talked about yesterday in terms of capacity, in terms of EC being mandated, in terms of the degradation effects that we expect will, you know, we will need to address in the near future. So, you know, maintaining the Terma radar as part of an overall system does not reflect the additional cost and risk that the airport is exposed to as a result of the wind farm. And you know, and herein I think lies the disparity in views. You know, I accept the applicant has a very different view to us, that they think once an initial investment in the Terma system has been made, that the airport bears no further costs and is not exposed to any risk. But as I said yesterday, that's certainly not the position that the airport holds.
And your recognition in paragraph 22 sets out, well, what it says is the issue is how that remuneration, i.e. the money that the airport's looking for, the issue is how that remuneration should be calculated. You've explained that the airport's willing to invest in equipment and staff training, 24 hours, 24/7 monitoring of services, upgrading hardware and software for a minimum of 25 years. So that in essence is the the actual costs that you see? I appreciate you've got your risk point, but those are the actual costs that you say will be incurred going forward. Yes?
No, no. Be very, very clear here that what we are talking about is cost and risk that comes as a result of the wind farm developments. It's additional cost and risk. We, are not stating here that developers should be paying for the replacement cycle of a Terma radar. However, what I am saying is that when that replacement cycle comes around in 10 or 15 years, we are exposed to risk because we don't know what technological solutions will be available to mitigate wind farms. We don't know what the cost of those solutions will be. We don't know what the compromises we'll need to make in the standard air traffic services functionality will be as a result of having to choose a wind farm tolerant system. So it's not about replacing the system and paying for the ongoing costs. It's about the additional costs that come because we have an obligation now to meet to the wind farm developers who have entered into agreements with us. So we're now obligated to provide that mitigation, and therefore we have to choose technical solutions that allow us to do that. And that comes with risk.
Sorry, when you say you're obligated to provide that mitigation, what mitigation is that?
Well, I'm saying we as a business, well, we're obligated to provide safe airspace. So that's our obligation to the CAA. So those things that we've accepted are in the environment, and we are now obligated through our CAA license to make sure that we've got safe airspace and safe systems.
Yes, and so I was more interested. I think you said that you were obligated through the existing agreements that you'd entered into to provide that mitigation, I think was what you said.
Well, I think you're talking about
mitigation.
I think you're talking about the nuance of language. What I'm saying is, in those agreements have been signed, and there is a contribution or however you want to term it, a payment that comes as part of those agreements, and that is to cover the cost and risk that the airport will be exposed to as a result of the wind farms that are in the environment. And I'm just highlighting one of those risks is, when we're in that replacement cycle for a Terma and we have to choose something that's wind farm tolerant, and we don't know what technology will be available, we don't know what the costs of that will be. These are all things that we have to consider.
Yes, but I'm interested in what your current obligations are. Wind farm developers have paid the airport to purchase and install a wind farm tolerant radar system, haven't they?
Well, no, the contributions to date are a payment that recognises that the airport is exposed to cost and significant risk over the long term as a result of the development. It is not limited to the acquisition of initial technology here and now. So, and this is again a point I'll make again, costs that are associated with mitigation are not just about the cost now of installing a system that has the capability to mitigate wind farm. We will be exposed to additional cost and significant risk for the lifetime of that wind farm. So where those payments that you have referred to are all upfront and lump sum payments, that's a payment that covers that cost and risk for the lifetime of the wind farm.
Yes, my point is slightly different though. You've been paid money to purchase, install and commission a wind farm tolerant radar system. Yes?
Yeah.
You are presumably under an obligation to those developers to then maintain that radar system.
Well, we have an obligation under our licensing to maintain the system.
You may have dropped out.
Oh, sorry, I think you're
Sorry,
dropping
Ms.
out.
Kilpatrick, you dropped out there.
Sorry, I think you're dropping out.
I think we were both dropping out. Can you hear me okay now?
I can hear you. I can hear you.
Yeah. Yes, what I was saying was we'd come back to the CA position in a moment or two, but so far as the contractual arrangements that you have at the moment are concerned, we've agreed that you've received money, you've installed, or you're responsible for installing and commissioning a wind farm tolerant radar system. And the question was, under those contracts, you're presumably then contractually obliged to maintain that system for a period of time.
Yeah. Well, yeah, well, but like I say, we're obliged under our licensing to, you know, to maintain safe systems, be that ATS or you know, the radar systems. That's part of our licensing obligation with the CAA.
And I say we'll come back to that, but you're contractually obliged to a number of wind farm developers to maintain the terma as well, aren't you?
Yes.
And how long does that contractual obligation last for?
In what sense? Do you mean how? Well, depends on how long the agreements are.
How long does the contractual obligation last for?
Are you talking about 25-year agreements or 30-year agreements? Is that what you mean?
Well, yes, I'm asking you, yeah.
Well, they vary, but yes, I'd say on average about 25 years.
And so those existing agreements presumably deal with the life cycle of the terma radar as well, yes?
What do you mean they deal with the life cycle? What do you mean by they deal with the life cycle? I don't understand your question.
Well, your evidence yesterday was that terma had a 10 to 15-year life cycle.
Yeah.
What do the agreements say in general terms about what happens when you need to replace terma?
Well, that risk lies with the airport. So the risk is the risk sits with the airport. The airport needs to find a solution to mitigate. It's the airport's responsibility to do that as a result of those agreements.
So you're contractually obliged under those agreements to put in place of its natural life.
Sorry, I'm losing you. Everybody's frozen.
Yeah, sorry, we lost you as well. Can you hear me now?
I can hear you. I can hear you.
Yes.
Right, no, I can hear you now.
Sure. I can hear you now. Okay. So the question was, are you contractually obliged to existing wind farm developers to install a new wind farm tolerant radar system when terma reaches the end of its natural life?
Well, we're not obliged to the developers to install a new radar. We're obliged to continue to provide, you know, mitigation. As I said, under our CAA licensing, we need to maintain a system that provides safe airspace. So we are obligated to do that going forward. That's our obligation. It's to the CAA. And the wind farm agreements that we are talking about provide payment, and those have all been upfront lump sum payment that recognise that there is an additional cost and risk burden to the airport in providing that mitigation, and hence the payment that is required as part of that.
So, as I said, we'll come to the CAA in a moment, but the agreements that you've entered into require you to provide a wind farm tolerant radar system for 25 to 30 years. Can we agree that?
Well, yes, that's what we need to do as a business, provide tolerance to those things that are in the environment.
Yeah. So there's a contractual obligation on you to provide that.
Sorry, Mr. McLeod, I can't hear you.
There is a contractual obligation on you to provide a wind farm tolerant radar covering your airspace for at least 25 to 30 years.
Well, we are, well, like I keep saying, we are obliged under our licensing to provide mitigation to those things that are in the environment in order to meet our obligations around maintaining safe airspace.
And you're under a contractual obligation to do so as well.
Well, that's not what I'm saying, and I'm not. I mean, well, maybe it could help, Mr. McFarlane, if you could tell me, you know, what it is that you want to understand about that.
Well, I'm sorry again, I'm sure it's me. I thought it was a fairly simple question. You have entered into contracts with wind farm developers that will last for 25 to 30 years. Agreed?
Mm-hmm. Yeah.
Those wind farm developers will pay you an annual fee determined by you, correct?
Well, no, those agreements, the agreements that you're talking about, the lump sum agreements, if you're talking about monies that have already been receipted, the new agreement is an annual payment, yes.
Okay. Let's move on then. So as part of the agreements you have with these wind farm developers, whether it's old or new style, you are contractually obligated to provide a wind farm tolerant radar system for your entire coverage volume. Is that correct?
I don't think it is. I don't think that is a contractual obligation within the agreement. However, it is a regulatory obligation that we provide safe airspace. But I would just caveat that I would need to check if that clause is indeed explicit within the in the agreement.
Do you have any contractual obligations to replace Terma with a wind farm tolerant radar system if Terma was to fail for any reason?
Well, we would be obliged under our licensing to
the license. I'm sorry to cut in. Not under the license.
That's the point I've just made. But Ms. McLeod, to be fair, I've just made that point. I said I would need to check on the you know, on the detail of clauses around conditions around Terma, and I can't talk to those.
You're surely not suggesting that you can't remember as important a fact as whether you're contractually obliged to replace the radar if it fails. You're not suggesting that, are you, Ms. Kilpatrick?
Well, I don't think that clause is in the contract, is what I'm saying. But we are obliged as an airport and as an aerodrome license holder to maintain safe airspace. So we would need to find a solution if the Terma broke, and obviously when it reaches the end of its life cycle, to find a system that could mitigate the impacts of the wind farms in order to create safe airspace.
And what then are the services that are provided under the wind farm mitigation services agreement? What does the developer get in exchange for its annual payment?
Well, I think
as far as radar coverage is concerned.
Well, I think I did say this earlier on when we were talking about it, that services probably isn't the most appropriate word to use here, and I do acknowledge that, and I don't think it actually represents what these agreements actually are, which is more of a strategic arrangement. I mean, we, as I've said on countless times, when wind farms are built in the environment, as far as our business is concerned, and as I explained yesterday, we believe that comes with additional cost and significant risk to the business that it would not have to bear if the wind farm was not in the environment. That agreement that is in place with the developer compensates, pays, remunerates, however we want to term it, the airport in recognition that it will incur additional costs and be exposed to significant risks as a result of the development. So I agree with you, because I think this is the point you're getting to, that services is probably the wrong word to use here and doesn't reflect what the agreement represents.
Okay. We've probably taken that about as far as we can. You've mentioned your regulatory responsibilities a number of times, and I wanted to look, please, at CAP 670 that I mentioned earlier on, which is CD 9.3.
I don't have that in the room with me. Mr. Cornelius can bring that in.
Yeah, sure. And
Yeah, sorry. Yeah.
warn you in advance, and it's made more unwieldy by the fact that page numbering is all over the place.
Oh, right.
So
Okay.
we'll take it as slowly as we need to. So for those who are working with the electronic version, the first page that I wanted to look at was page 64. And that is, it begins with paragraph A58. Ms. Kilpatrick, which
Which
is,
page am I? Which page am I?
well, it's page 10, but it's one of a number of page 10s. That's the problem. So you'll see there's a long section of tables to begin with. There are then some definitions which follow on from that. There are then some acronyms, and we then get to directory, and then part A, which is headed the regulatory framework. Still quite early on in the document.
No. Is it past abbreviations?
Sorry, beg your pardon, say again?
Is it past abbreviations?
Yes, just past there.
I'm into directory.
Directory, and then if you go on one further page, you'll get to part A, the regulatory framework.
Sorry, sir, I hesitate to intervene again, but Ms. Cornelius has suggested that she provides a laptop with the electronic copies of the documents available on it, if that makes it easier.
That would probably be helpful for everybody. Yes. Thank you.
If we just have some time to set that up, just a few minutes.
Okay, very, very well.
Oh, right. Okay.
Great. Okay. Hopefully that will make life easier for everybody.
What page? You just remember what page number it was on the electronic?
Sure, yeah. So electronic page 64. And that should begin with paragraph A58.
Sorry, I'm just not on that yet. This isn't my. No. 64. Right. Okay.
Yeah, got that. And then the section that I wanted to look at with you was about 2/3 of the way down the page, regulation of air traffic and air traffic service facilities. A64, international standards and regulation are in force, which states are required to implement. It then talks about the ICAO document, and then in A65, ICAO Annex 11 requires the CAA to implement a program that ensures a safety management system is used at all ATS units. And you'll be presumably broadly familiar with that requirement. That's what CAP 670 then goes on to do, isn't it?
Well, I'm not here to talk about or to talk to regulation, because that's not my role, but yeah, I am aware that we have a safety management system, yes.
Yes, indeed. And we can see from A65 that it's a legal requirement under the European Commission regs for ANSPs providing ATC to operate an SMS. So again, legal requirement on the airport to operate a safety management system. If we then turn to paragraph 71, which is on the following page. You have that?
Yep.
A71. An acceptable safety management system should address all the principles described in CAP 670 Part B, Section 1 at 01, and will document the strategies by which the stated objectives are to be achieved. So, again, in general terms, that's what you must do, and you presumably have a safety management system in place that deals with these aspects. Otherwise, you wouldn't be operating as an airport.
Yes, that would be part of our licensing responsibility.
Yeah. I want to look next at page 75, please.
A75, A75.
Oh, sorry, electronic page 75.
I've got that.
Yep,
I've got
that. And that's the part that was just referred to in one of the earlier paragraphs we looked at. You'll see it's headed Safety Management Systems. And it says, where APP 1.3, where approval under the Air Navigation Order is required, it's the responsibility of the service provider to satisfy the CAA that the system under consideration will be safe for use by aircraft and satisfies all appropriate requirements throughout its life cycle. So that is something, again, accepting you're not an expert in this area, but that's something that would apply as far as the Terma radar you're commissioning is concerned, isn't it?
Yes, this safety case has to be accepted by the CAA.
And you'll see from APP 1.4 that this applies both to the initial approval and any subsequent changes to the approved system. So that again is the responsibility of you as service provider under the terms of your license.
Yeah.
So those are existing obligations that you have to the CAA, notwithstanding this wind farm proposal.
Yes.
Okay. And then I'd like to look next at electronic page 77, which is headed Maintenance Arrangements. And this, I think, may be where we come across the term maintenance as you refer to it. But halfway down the page in APP 02.5. Sorry, beg your pardon.
Sorry, I'm on 77 now. Which part?
Yeah, so you'll see about halfway down the page in APP 2.5, there's a note at the end of it. And it says, note, the term maintenance includes the operation, regular maintenance, repair, modification, overhaul, and decommissioning of ATS equipment. So is that how you use the term maintenance when you refer to it in your evidence?
Well, no, because that's very much still about the equipment itself. I mean, we're talking about maintaining all of our obligations that we are required to do as part of our licensing obligation. But again, and I'll make this point here, I am not here to talk about, you know, CAP documents and regulatory documents. I've referred to them in very, very loose terms when I've talked about them, because I do not profess to be an expert in all the CAP documents, and nor do I need to be in my role. Mr. Fido, yeah, well, you've already spoken to Mr. Thompson, who talked about safety. Mr. Fido will come and speak, no doubt, to CAP 670 in more detail. But you know, this is not an area that you know I would expect to be talking to, you know, in any great level of detail.
I understand you might not expect to be talking to, but we are where we are. Your evidence to the inquiry talks about requirement for maintenance, and what I'd like to explore with you is whether your understanding of what's required accords with what the CAA says you as a service provider must do. So let's just go back to the beginning of that section. APP 2.1, maintenance arrangements will normally be considered as part of the SMS Safety Management Service acceptance or approval as part of the certification design process. So I'm not an expert in this either, but in general terms, I read that as saying it's something that needs to be done at the outset before something happens.
Mm-hmm. Mm-hmm.
Yep. We can see then in 2.2 the safety objective, and that safety objective applies regardless of this wind farm, doesn't it? The requirement that equipment management arrangements are adequately safe to ensure air traffic management facilities remain fit for purpose. That's a general obligation on the airport, regardless of this wind farm.
Yeah.
In 2.3, as part of the safety case, the ATS provider should detail the maintenance arrangements applied at the ATS facility. And again, we've looked at the term maintenance, and that can be seen below. So the maintenance arrangements that are required include operation, regular maintenance, repair, modification, overhaul, decommissioning of all air traffic service equipment. So that's, in essence, that's the operation and maintenance and overhaul, if necessary, of the Terma wind farm tolerant radar system.
Yeah, I would interpret that to say I'm not, I can't say I've read CAP 670 from cover to cover, but my interpretation of that would be maintenance of the equipment system, which would extend beyond Terma.
And then if you were to scroll from pages 78 to 83, you can do this in due course if you want to, but you take it from me that it contains a lengthy list of the issues that Glasgow Prestwick Airport should consider as part of achieving your safety objective. if it helps, we can look at a couple of examples. So for example, page 79, maintenance arrangements. That sets out all of the things that should be considered. Safety adequacy of the following arrangements should be considered by the airport. That's as part of the commissioning of Terma.
Yep.
And then bottom of page 80 onto 81, maintenance support arrangements. So safety adequacy of the following arrangements should be considered. First bullet, service agreement with any third party providing maintenance or installation services. That's presumably the arrangement that you have with Terma, or I think possibly NATS provide the service on behalf of Terma in the UK. Is that correct? Yeah. So you have a service agreement with NATS related to the radar system you're installing to ensure that it's adequately maintained and serviced on an ongoing basis.
Yep.
And that's been paid for already.
Well, it's an ongoing cost.
Okay, let me put it a different way to you. That you have money in the bank that would allow you to pay the annual charges for that.
Well, yeah, we do pay the annual charges for that.
Sure, Terma will be reassured by that.
Yeah.
If you look next at page 81, see the section headed competency of personnel. So we've got to consider things such as number of staff committed to maintenance and repair programme, staff certification schemes and policy, staff qualification, competence specialisation and recency, staff training policy and plans, etc. So those are all things that you must already have considered, presumably, to ensure that you have a safe operating system once Terma is commissioned.
Yep.
And those are obligations that you have to the CAA, whether this wind farm proceeds or not.
Yes.
Now, taking all of those things together, basically, everything you've listed in paragraph 22 of your precognition is the airport's responsibility already as part of its license, isn't it?
Well, again, and I'll say this again, Mr. McLeod. The reason that the mitigation agreement is required and payment is required is because the airport's position on wind farms is that when they are built in the environment, it has an impact on our operations, and the impact of those operations generates additional cost and risk in the long term, which will also attract costs as well. And it is not fair and reasonable for the airport to be exposed to those costs that come as they're not to do with our commercial activities. Now, that agreement and that payment is not to pay for our core services, as you've quite rightly pointed out, that we are obliged to provide in the course of doing our business and holding a CAA license. What we're talking about here is additional cost that comes as a result of the wind farm, not the cost that we incur to operate the radar, as you quite rightly point out, that we need to run our operation. And I did reiterate that point earlier on. Again, we're not talking about the cost to replace Terma in 10 to 15 years and then 30 years after that. We're talking about the cost in terms of the risk that we'll be exposed to, because we have to find a technology that will mitigate. We don't know what that will be. We don't know how much it will cost. We don't know what other additional capability we will need to invest in as well, because that technology that allows us to mitigate wind farms will give us compromised functionality in the rest of the system. So I'm not positioning here that developers should pay for our core infrastructure. I'm positioning here that the agreements are to compensate the airport for the additional cost and risk. Now, you are very right in pointing out that the very original agreements that were entered into were capital contributions. It was for that initial investment in an initial solution that had the capability to mitigate wind farms. So they were the original agreements that allowed for the procurement of firma, but that's not the basis on which the agreements are formed now.
No, I understand that. But to try and summarise this, at a point in time, I think possibly before your employment, agreements were entered into where wind farm developers paid for the construction of a new wind farm tolerant radar system, correct?
Yes, yep.
After a lengthy period of time, that wind farm tolerant radar system is to be commissioned and brought into operation this year. Agreed?
Yes.
Yep. As part of the commissioning of that system, you must provide a safety case to the CAA, which covers all of the matters that we've just discussed. Yes?
Yes.
And those matters cover, again, just go back to the term maintenance, which is on page, I think it was 76 possibly. Sorry, it wasn't 76 at all. It was 77. The term maintenance includes the operation, regular maintenance, repair, modification, overhaul, and decommissioning of the ATS equipment. It is an extensive obligation that you have to the CAA, regardless of this wind farm development. Agreed?
Yes. Oh, I've lost Mr. McLeod.
To the obligations that you owe.
Sorry, Mr. McLeod.
To the CAA.
Oh, Mr. McLeod, sorry, you were breaking up and I didn't hear that. Oh, you froze again. Yeah.
We're both breaking up.
Yes, you're coming and going, Mr. McLeod, but if you seem to be back with us again now, so if you want to start that question again.
Certainly. Sorry, can you hear me okay now, Ms. Kilpatrick?
Yeah. Mm-hmm. Yeah.
Yeah.
Mm-hmm.
So my question was, this wind farm development will make no difference whatsoever to the obligations that you already owe to the CAA at the point of commissioning the Terma radar, will it?
No, but we will have to provide, if that development is indeed built out, then it will require its own safety case, you know, as part of the safety assessment process. The development won't be built, will it, when Terma is commissioned?
The payments that you're looking for on an ongoing basis are to give you comfort when it comes to risk. Yes?
Well, we recognise that there will actually be some cost now. We can already see that there will be some cost, but when you're looking at a period of time that is so far out, clearly becomes risk because you don't have sight of what it will be.
It doesn't really have any relevance to planning, though, does it? It's more about giving the airport comfort on an ongoing basis.
Well, it's not about comfort, is it? We're talking about an activity, the developer's commercial activity, having an impact on our business that, you know, in mitigating that impact, you know, means that the airport is going to bear additional cost and be exposed to significant long-term risk. As I keep saying this point, it's not about giving us comfort. We know that we will bear additional cost and there will be risk, and therefore you know, that's why the payment is required, because it would not be reasonable to expect the airport to bear that cost. And as I said earlier, the DfT's position is, you know, very, very clear that the costs of mitigation should be borne by developers who benefit commercially from those activities.
The issue, though, may be down to your definition of mitigation and the DfT's definition of mitigation. Do you accept that?
Well, I think you know, clearly we both have different views, or the applicant and the airport have different views on what mitigation is required. The applicant clearly believes that mitigation isn't required. We believe that mitigation is required. So, you know, again, those things are to be discussed in the technical sessions with the appropriate people. But clearly we have a difference of opinion here.
Perhaps finally then, and on that point about the difference of opinion, you, as an airport, an objection by an airport clearly carries a great deal of sway, and we can see that from the fact that South Ayrshire Council, no, not pejorative intention here, but they piggybacked on your objection. They said that because the airport had objected, they would object for the same reasons, in effect. Do you understand that?
Yes.
So you carry a significant amount of clout when it comes to the planning process here, don't you?
Well, we're a statutory consultee, so.
And from that perspective, you're really you're the only person, you're the only people who can say what you believe the impact on your radar system is going to be, aren't you? You know, it's you either enter into an agreement with the wind farm developer or you maintain your objections. Simple as that.
Well, it's not just about the impact on the radar. There's, you know, there are other things that need to be considered as well, and you're taking quite a narrow view. But yes, you know, we clearly have to remove our objection for the planning application to proceed, assuming that we're the only objector.
Well, I'm really just going by your radar safeguarding assessment process, which is GPA 22.
Yep, got that. Yep, got that.
And what we have there is we've been through this with Mr. Thompson, I think, but you're consulted. Step 1, you undertake your radar line of sight analysis. Step 2, are the turbines visible? Yes, then you object. Now, Mr. Thompson's said something about the operational impact assessment, but we don't have any written evidence of that before the inquiry. But in essence, this document which you've produced shows that if the turbines are visible, you will object, come what may.
Well, I think, to be fair, Mr. McLeod, we've already had a session on this that he spoke to Mr. Thompson, and you know, I'm not here to talk about the GPA 22 document in the sense that you're asking. You've already asked Mr. Thompson about the process that he goes through when assessing whether or not to object to a development.
Yeah. But within that process from step 4 to step 7, there doesn't seem to be any way for the wind farm developer to get out of signing a mitigation services agreement. Once the objection has taken place, you're on a one-way path to this agreement, aren't you? Well,
we have to find an agreement, and we have to find a way in which we can coexist. So you I think are not being very balanced in the way you're presenting that, because you are failing to acknowledge that the airports having this development imposed upon them. You know, this is not, we're not out marketing you know, mitigation for wind farms. The developments arrive in our environment and they are imposed, and they have an impact on our business, and both developers and airports. And this is not just about Prestwick Airport and the applicant. This, you know, these arrangements are the way that the objections are dealt with across the country. This is not a, you know, a Prestwick Airport and an SPR unique situation here, but we have to find a way in which we can coexist and we get to a situation that's acceptable. So there's a situation that's imposed on the airport, and we need to find a way together to reach an acceptable solution. And hence, the need to share the agreement and then sit and have a discussion with the developer to discuss the terms of that arrangement.
But it does seem, and again, I accept you're not a technical witness here, it does seem that from step 4 onwards, there's not really much scope for agreement with the airport to withdraw its objection. Once you've reached the view that there's going to be an impact, you want the developer to sign up to a wind farm mitigation services agreement, don't you?
Yes, for the reasons that I've explained. Because you know, the development has an impact on the business, and we, you know, as far as we're concerned, and to be fair, this is an industry-wide view in aviation, and there is, you know, maybe a disagreement in views on this, which we've touched on in earlier sessions. But you know, the view that Prestwick holds is not unique to aviation. You know, as far as the aviation sector, and well, I can't talk for the aviation sector, but it's not, you know, if you asked other airports or ANSPs, they would some kind of compensation or payment in return for taking on that risk burden for a long period of time.
Ms. Kilpatrick, we lost you just for a second there. I think I did get the main flow of what you were saying, but
probably something I've already said.
I think it was reiterating a point you'd already made. But if there was anything particularly important in what you just said, then by all means repeat it.
No, that's fine.
Well, maybe then just to summarise your position, you require the applicant to enter into a wind farm mitigation services agreement, but you're not able to specify any services that will be provided, correct?
Well, I think again, covered that twice already, that services I would accept is probably not a very good word to use in the description of that agreement. So I've acknowledged that that probably is not representative of what the agreement is. And I think I've explained what the agreement is for.
Well, let me put it a slightly different way then. Let's strip out the word services. You want the applicant to enter into a wind farm mitigation agreement, but you're not able to explain to the inquiry what that mitigation is.
Well, no, I think I have explained why the agreement is required. It's required because the commercial activity of the developer in building a wind farm in the environment has an impact on our operation. That impact would not exist if the development had not been built, and the impact of that development needs to be mitigated by the airport. That derives additional cost and risk over the lifetime of the wind farm. It's not a commitment that we undertake for 5 years or 10 years. These are 25, 30 years, possibly in perpetuity undertakings, and it comes with additional cost and risk.
And you're not willing to set out the basis on which the applicants would be charged to this inquiry?
Well, as I've said, Mr. MacLeod, we have tried for a long time to have a normal, sensible commercial conversation with the applicant about the terms of the agreement, the charges, our views on risk, etc., but that hasn't been possible. You are correct that I am not going to talk about the details of the commercial agreement in this public forum, but as I've already said, I would certainly be more than willing to share with Mr. Hall the details of the agreement and the charges for his, so he is aware at least of the quantum that we are talking about.
But at the end of the day, to be clear, it's a quantum that you will be happy with, or you will not enter into the agreement. It's set by you at a level that you are comfortable with, not by reference to any particular services, not by reference to any particular mitigation. It's what you are comfortable with commercially.
Well, it would come at the end of a negotiation. So, cost will inevitably form part of a negotiation on wind farm mitigation, as will various other terms. So, both parties sit together and have a conversation about that. But you are absolutely correct that until the airport's in a position that it feels comfortable with about the risk and cost that it's exposed to, then which will be covered by the mitigation agreement, then the objection is not removed.
Just bear with me for 1 second, sir, please.
Fine.
Thanks very much, sir. Those are all the questions I have for Ms. Clauchrie.
Thank you. I think given we're now past 1 o'clock, we'll have a break for lunch there. So I'll come back with my questions after lunch, and Mr. Brown may have some questions for you as well. If I could remind you not to talk to Mr. Brown during the lunch period.
Yeah.
Thank you. So we'll come back at 2 o'clock, please.
Thank you.
Thank you. Good afternoon. Are we all back again? Ms. Kilpatrick, I can see you there. Good. I have a few questions for you, Ms. Kilpatrick. First of all, just a point of clarification on your recognition, paragraph 22 of your recognition. There you say that the airport is willing to invest in a number of things. So I'm taking from that what you're saying is that these items that you're listing at paragraph 22 are not things that you'd be expecting the developer to fund. These are things you'd be doing anyway.
Yes, yeah.
And then on paragraph 23, so if the sums that are to be paid are going to be left to a commercial negotiation between you and the developer involved, could there be a situation where you might have two similar wind farms, each with identical impacts on the airport's radar, but they would end up paying different amounts, just depending on how the negotiation went?
Well, there is a mechanism within the charging structure that allows for what we call contributing capacity, and that sees the charges. So as I'd explained yesterday, there's a banding structure for charges, and each band has a different rate, and the bigger developers get a discount on the rate. There's a recognition about the overall impact in that figure. So yes, in that scenario, there could be a situation where a larger developer who has more wind farms could pay a lower charge for a wind farm within its group of wind farms than a single developer.
So that banding structure, you're speaking as if that's a fixed thing then. So there would be a level of negotiation with individual, perhaps about the wording of the agreement, but the banding structure and the payments required within each band, that would be the same across the different agreements.
Well, I mean, there's always a discussion around pricing with developers, as I'm sure you can aware. That's probably the main thing they want to discuss, and there is a level of discretion around some of the higher bands in terms of overall capacity. So the lower bands are, relatively fixed, but the higher bands are open to negotiation.
Thank you. Then paragraph 24 of your recognition. This is where you say the airport's not obligated to provide services to its customers on a cost recovery basis. So are you saying that it's reasonable for the airport to make a profit out of any financial arrangement with the applicant?
No, to be absolutely clear about this point here, this is very much about the operational expenditure that is associated with work carried out in direct relation to wind farm matters. Now, we've talked about resource, or talked about resource quite a lot yesterday. Some of the exercises that we have to undertake, like safety cases, or actually just the scoping and procurement of technology, and I'm talking about things here that would be specific to the wind farm, not the normal general surveillance system for the airport. But if we have to do something over and above that as a result of a wind farm, there's a huge resource requirement in the scoping, procurement, installation, commissioning, building of a safety case, as we've demonstrated with Terma. So there's a lot of human resource there that we would place a value on. So cost recovery, I would interpret to mean the cost of somebody's employment. So you are recovering the cost of that employment. And as a commercial organisation, we would place a value on our employees' time over and above what it costs us to employ them. So that's what I mean by not on a cost recovery basis. If we're doing something that comes as a direct result of a wind farm and we're dedicating staff time and resource to that, we wouldn't charge it at the cost of employment of that person. In a similar way, I suppose, could explain if we provide security guards at the airport in going about our aviation business, if we were to provide a security guard, for example, we would have a rate for that security guard which would be over and above what it costs us to employ that security guard. If that makes sense.
I think so. Are you saying that? Well, from the first part of your answer, I took you to mean that, or perhaps the direction I thought you were going in was saying that there are some quite complex, wide-ranging pieces of work that need to be done, and it's quite difficult to identify, or that particular wind farm is giving rise to this particular cost in terms of a much broader ranging piece of work, which will contribute to mitigating the wind farm's impact. So was that part of it? And then, in the second part of your answer, you were talking about the direct costs of employing an individual, and that's I didn't quite follow what you were saying there. If you could maybe put that in a different way.
Yeah, no, that's fine. The point I'm trying to make is that when we look at the charges that we levy as part of the mitigation agreement, part of that will be based on cost and time of people. So that forms part of that burden that we think we are exposed to over the long term, directly associated with activities that come as a result of the wind farm. And as a commercial organisation, we place a value on the time that we spend on an activity over and above what it costs us
I see.
to employ people. Do you see what I mean? So cost recovery.
Yeah, I'm with you now.
Yes. Yeah.
Yeah. Sorry, it's because I'm having to write things down at the same time as you're answering, so my brain can't do two things at once. That's fine. Now, you were taken to GPA 22, which was this flow chart.
Yeah, I do have that in front of me.
The safeguarding assessment process. And this was in your evidence in chief, I think, when you were going through the various costs that would be in potentially the airport might have to bear. And you pointed to steps 6 and 8 and 14 and 15 as potential areas where there would be costs on the airport. And then you went on to describe a whole series of other potential costs beyond those. So I'm correct in that, am I? The costs are not limited to those steps in GPA 22, but there are other costs as well.
Yeah, this is just the safeguarding process, so it's a very first stage.
And then, yes, that's what I thought. And then you went on to list these other potential costs. But when you were giving that answer to Mr. Brown, were those still just examples? You weren't setting out to give an exhaustive list at that time?
Yeah, and it can't be an exhaustive list. And I suppose, herein lies the issue for the airport, that we are trying to look out to 25, 30 years potentially in perpetuity at what costs we will be exposed to as a result of risks, which can come in many forms. And the examples that I gave yesterday were just examples of those risks that we're already considering now and think could be very likely to affect us in the short to medium term, and those would come as a direct result of the wind farms in the environment. But it was certainly not an exhaustive list because we don't know what the future holds.
So looking at maybe you'll say that the wind farm service agreements that you've signed so far took a different form because they were about a single lump sum payment, as I understand it.
Mhm.
Well, is that the case, that you haven't yet signed? Am I right in thinking that this would be the first one that would be of this new form with the per megawatt payment? Or
No, we've signed several of the new agreements, so that the new agreement was signed off by the board around about 12 months ago. And
okay. So those that you have signed then of the new form, they don't attempt to set out the particular matters which the receipts would be used to pay money for.
No, well, we clearly have a dialogue with them about about the agreement and the charges, and inevitably the developers will ask us to explain why we need to charge and on what basis we're charging. But we can't provide receipts for things in the future that we don't understand at the moment, and the business has to take a view on a level of risk and exposure over the long term, and put a value on that, because ultimately we have a responsibility to our shareholder to make sure that we are not financially exposed in 20 or 30 years time as a result of activities that come from another commercial organisation's activities.
Do you think, I mean, you say that it's very difficult to set down in paper what the potential costs might be in 25 years' time, but would it be possible to do that at quite a high level? I mean, you've been taken to parts of planning guidance where it says that we don't need to think about every possible eventuality. So, I mean, there may be, who knows what new types of development or technology may exist in 20 years' time, but in broad terms, drilling down too deeply, would it be possible to set out sort of the broad areas where monies might be required?
Yeah, I mean, I think the broad areas will be in additional capex, capital expenditure, and operational expenditure, and I think they could be, very, very significant. So we're talking about, millions and millions of pounds here, and bearing in mind that we're looking at a window of 30 years potentially in perpetuity. It could be very, very extensive, and I think Mr. Fido's session will be very useful in actually starting to in technical detail actually explain the impact that these structures have when they're placed in the environment and the air traffic need to manage, which goes way beyond clutter and the potential consequences for airports that need to deal with that for 25, 30 years, 40 years.
And where I'm coming to on this is about the condition that the particular condition that the developer is worried about, concerned about. And I'm just wondering if we could give any comfort to the developer by being a bit more specific in that condition and setting out in a bit more detail how the money would be spent, what items it would be used for. But I take from your answer that you don't think that's possible.
No, I don't think that's possible, because we're trying to evaluate a situation that has a lot of risk over a long period of time.
Thank you. I think we touched on this in one of your earlier answers about the per megawatt payment model, and you said there are different bands, and so the amount paid per megawatt might differ between different wind farms depending on the size of the developer or the number of wind farms they have. So is that the only factor? Factors like distance from the airport, or effect that a particular wind farm would have on flight paths and so on, those factors aren't considered?
No, I mean, we do think and I know the applicant doesn't share this view, but we do think that there is a correlation between the megawatt output and the impact that it has on our operation. And again, Mr. Fido can talk to that in a bit more detail. So we do think there is correlation there. I think I said yesterday when I was giving my evidence in chief that this is a fairly standard way of calculating charges for strategic support on mitigation. So it's certainly not unusual, and it is accepted as a standard industry practice, I would say, by airports and developers alike.
If I was to categorise the per megawatt approach as being the best proxy that's available for the impacts on the airport, would that be fair?
Yes, yeah, and I'm not aware of any other form of agreement. Now, there may well be a different form that another airport has, but I'm not aware of one.
Thank you. Now, I'm going to quote from a document you may not be familiar with, which is the Scottish Onshore Wind Policy Statement, which PD .12. If you're not working electronically and you haven't, I wouldn't ask you to print it off. But paragraph 64 of that, I'll just read it to you, and it says, wind farms are no longer the new and unexpected feature that they once were and an established part of Scotland's landscape. Given this, we expect in the longer term a move on the part of the air navigation industry towards self-management of this issue. So I'm interested in how you'd interpret that statement and whether you think that's meaning that in the longer term, airports should be moving towards covering the costs of mitigating the effects of wind farms themselves.
Well, first thing I would say is that that's an onshore wind policy document as opposed to you know, a CAA or a DFT policy document, and it's clearly an aspirational position on the part of the renewable sector to reduce the overall cost of their projects and increase the returns. The DFT position and the cost of mitigation is, you know, is a matter for it's a reserve matter, and we obviously refer to the DFT and the CAA on that and their position.
Yeah, I would say that's the Scottish Government paper.
Yeah.
But you're right about it's not a UK government paper.
No, and it's an aspirational statement, I would say, from the renewable sector. The DFT's position is that the cost of mitigation should be borne by the developer who benefits commercially from those activities.
Thank you. And then my final one, just coming back to a point I didn't quite understand in an answer you gave to Mr. Cloud, which was, I think we were talking about the negotiation over the wind farm services agreement, and I noted you down as saying that if you couldn't reach agreement, you could go to the regulator for mediation, and I think it was clarified that that would be the CAA. But can you describe it in a bit more detail how that would work?
Well, we've never had any discussion on wind farm mitigation agreements refer to the CAA, so I know that they are obviously available to mediate should that be required. I've not been through that process myself, so I can't describe it in any great detail. I was just trying to highlight that, you know, should the parties not be able to reach a mutually acceptable position on that, that there are other ways in which that can be escalated.
So there's no formal process set down, but you'd envisage that a wind farm developer, if they were dissatisfied, they could write a letter or call a meeting with the CAA and yourselves, and then would the CAA have any powers to make a determination as to what form the agreement should take?
Well, it's called a call-in as far as I'm aware, so there is a process called a call-in for review. Like I say, we've not been through that process, so I can't comment on that in any great detail. But you know, they would clearly want to understand the reasoning and rationale that the airport had used in its decisions.
Okay, thank you, Ms. Kilpatrick. I'll put you to the capable hands of Mr. Brown now and see if he's got any further questions for you. Mr. Brown.
Thank you, sir. I've got no questions for Ms. Kilpatrick.
Thank you then. Thank you, Ms. Kilpatrick, and I'll ask Mr. Brown to lead us. No, we're going. I assume the order now is for the applicant to lead their radar witness now. Is that correct, Mr. McLeod?
That's correct, sir. Yes. So I'll just check that Mr. Inglis is set up, ready to go. Yep. What I intended to do, sir, was not to have Mr. Inglis read out his entire precognition. There are a few points in both his inquiry report and his precognition that probably need to be updated in light of the responses that were received from Terma. So it might be as well if everybody has available a copy of the Terma response, which is CD 9.29, and then also a copy of Mr. Inglis's inquiry report and his precognition. And the inquiry report is APP 3.2, if that helps.
I have those, yes.
Great. Okay. So, Mr. Inglis, if we start with your inquiry report, we can see in 1.6 your extensive experience and the fact that you've been employed by both CAA and NATS at various points in your 35-year career. There's probably nothing, I think, that needs updated in section 1. But when you get to section 2.4, please, on page 7, I gather that you've got some updates to paragraph 2.4.2 in light of what Terma has come back with.
Yes, thank you, sir. Let me respond to that. So we sent some questions that were mutually agreed by both parties to Terma that clarified some of the processes that were required as a result of having wind turbines. And in 2.4.2, we talk about the optimization process associated with introducing new turbines and the ongoing maintenance. The response from Terma that was received states that the optimization is very limited and comprises of data entry of the wind farm turbine locations. And more importantly, they categorically say there is no additional maintenance, engineering maintenance, required to the system as a direct result of having wind turbines within the radar coverage. So that kind of supports what was originally in my report.
Okay, thank you. Next, please, if you turn to paragraph 3.2.3, and this was a section of your inquiry report where you had referred to the Terma white paper. And again, if you'd just like to update the inquiry on your position in light of what we've now heard from Terma.
So this clarification was regarding the work that's been done since the white paper in 2012. And Terma responded that over that period of time there have indeed been a number of changes. And those changes included enhanced processing and tracking capabilities. And so the developments in the last almost 10 years would have improved performance since the white paper, as you might reasonably expect.
Thank you. Next, section 3.3, and this is to do with the worst case reduction factor. And it might be worthwhile just having a quick look at what Terma said on the worst case reduction factor and its response as well.
Yeah, so the worst case reduction factor in principle was something that we applied and we interpreted. I'll just make it clear that Terma did not help us with the calculation or indeed have any part to it. It was only the principles that we discussed. And the worst case reduction factor gives you a feel, as the name suggests, for the reduction in detection that you might experience over a wind farm. We asked about the influence of having turbines spaced, the inter-turbine spacing being greater than 500 meters, and what effect that might have. And Terma did respond that while that was a factor, there were other factors to be considered. And they do indeed detail them in one of the responses. I think they, without referring to it directly, they were talking about the range of the turbines from the radar head being critical. And we did factor that into our calculation at the time. Obviously, the further you go out, the bigger the range cell sizes, and that influences how the turbines are processed.
And it may be, actually, just maybe look to the reporter for a bit of guidance here. Sir, would it be helpful for you to hear about how azimuth is calculated and what that, not in detail, but just the basic principles of it in terms of the approach that's taken?
I think that might be as well. Yes. Yes.
Yeah. Okay. So, Mr. Inglis, if you could maybe just explain how that then works, and the way in which radars operate over a range, if you like.
So within the radar coverage, you can divide the radar into a number of cells, and those cells depend on the size of the cells, both in azimuth and in range, can vary. Typically, the range cells don't in terms of distance. So if you imagine the spokes on an old-fashioned cartwheel, as you go further away from the radar head, the size of these cells gets bigger. And the chances of having multiple turbines within those cells increases, and the radar will then struggle to separate out the turbines within those cells. So we currently sit at about 20 nautical miles. So we did a calculation, and there are calculations based on the antenna beam width, how sharp a pencil point that the radar beam is, and we calculated the arc size of the cell, and we obtained from Terma their range cell size. So that's how we calculated the area of the range cells, and I think Mr. Fido would have done the same thing in terms of calculating those sizes.
And we can see the graphically in both figures 2 and figure 3 in your inquiry report. I think that the process that you've been describing there, where one looks at the beam from the radar as being two spokes from a bike, as you described it,
yeah,
and how those fan out over a distance.
Yes.
I think there's one change that needs to be made to the calculation in 333, and that's in the third, well, the final bullet point, the second last and the third last, where you refer to 0.6%. Should that be a different figure?
So we calculated the reduction factor as using the principles that Terma provided, and we came out with the 0.6% over the wind farm. There was another figure that looked at what a minor drop over the wind farm would do to the probability detection within the entire radar coverage volume, what's known as the declared operational coverage. So I'm not sure it's a difference, or as we could have probably presented it a little bit better than we did. If you have a very small drop in PD over the wind farm, the effect out to 45 nautical miles over 360 degrees on the overall probability detection is absolutely trivial. So, and we calculated that. I think there was an extra couple of zeros in when you factor that in, so 0.006%.
Yeah, so in the third from last bullet point, where you say, therefore turbines occupy 1,080,000 divided by 1,380,000 equals 0.0056, or approximately 0.6. That should actually be, or approximately 0.006% of wind farm area. Is that correct?
I probably should have just left it as a number and not put the percentage in, but it's I think that's the clearest way to do it. Percentage-wise, it's a very small number in absolute terms.
Okay. So far as the point about probability of detection is concerned, the reporter has a calculation from you. He has a calculation from Mr. Fido. Does the Terma response assist him in determining which way is best or most appropriate to do the calculation?
Not really. I think the principles we followed and the principles Mr. Fido followed are very similar. We disagree slightly on where to measure things from, so the definitive answer would probably have to come directly from Terma.
So you accept that there is a calculation to be done, and that really that's something for Terma to do at an appropriate point in time.
I think everyone would be, well, I assume everyone would be comfortable with a manufacturer being best placed to do the calculation if we have different answers between ourselves.
Thank you. Next, and I think this is the final point in your inquiry report that I wanted to pick up, was in the conclusions section in 5.1.3. And the last sentence of 5.1.3, which reads, the TS 4002 radar does not require additional ongoing maintenance or performance assessment, e.g. routine dedicated flying, due to the presence of wind turbines as confirmed by Terma. You've now seen Terma's further comments, and what do you say about your views in relation to those?
So Terma agree. The answer was, we asked the question, do you require any additional maintenance as a result of having wind turbines within the coverage volume? And the short answer was no. And there's nothing in addition that engineers maintaining the system would have to do. There's nothing in addition to monitoring performance for the purposes of safety assurance. It's not relevant to the wind farm. Some of these things, as we came across earlier, are mandated anyway by the CAA. There's no extra burden as a result of the wind farms.
Thank you. Then if we could turn please to your precognition, and just the same process, which I think will be fairly brief. first section is section 1.5.2 under the heading of radar performance, proposed TS 4002. And in this section, I think again, you'd been relying largely on the Terma white paper from a few years ago. And if you'd just like to update your comments in relation to that following the Terma response, please.
Yes, so we were interested to know Terma's view on ground clutter, because I think Mr. Fido had used the wording of masking ground clutter. Ground clutter in the response from Terma is one of the things that would need to be considered when assessing the performance. But it's something you would assess at the time of initial commissioning and before entering operational service. And Terma say that high clutter levels in specific areas that may impact the performance of a radar, whether it gives rise to concern, is up to the end user and the operational requirements. So many radars have varying performance across their coverage volume, and in some areas you may indeed have higher clutter levels than others. Whether that has an operational impact or not is something that needs to be considered, and in many cases it has no impact whatsoever. So Terma didn't answer perhaps as explicitly as we'd have liked, but as with all radars, be it a wind farm tolerant or not, ground clutter is something you sort out in the initial stages of commissioning. And from my experience, that's typically by changing the antenna tilt so you don't have so much energy pointing towards the ground. So for the Terma at Glasgow Prestwick Airport, I would expect as part of the initial commissioning that to be addressed and to get the ground cluttered down to a level that the processing within the system could manage.
Thank you. Next was 1.6.2. And I think this is possibly a point that you've covered already from your inquiry report.
Yeah, this is just reiterating the fact that there's no additional maintenance requirements as a result of having wind turbines within the coverage volume. But yes.
And then finally, on your recognition, paragraph 1.8.1, please.
So there was, in our original report, we discussed, or we said there may be some optimization required. Terma have clarified what that might be. Following a radar entering operational service, if you had another wind farm developed nearby, what would you have to do? And the response in their questions say that the manual intervention required is to put the location of the turbines into the system, the coordinates. They do not state any other optimization is required. So I took from that it's a relatively trivial task. It's a task entering data that sounds quite straightforward and would be trained, the engineers maintaining the system would have training on. That said, I do accept that it's not something they would be doing routinely. And if they weren't comfortable with doing it because they're not doing it routinely, having Terma come along to enter the coordinates would probably be a prudent thing to do.
Okay, and then just a couple of final questions arising from evidence we've either read in others' recognitions or heard recently. You'll remember Ms. Kilpatrick's evidence about what might happen if electronic conspicuity was mandated, and the fact that there might be additional costs to the airport arising from wind farms. Can you just explain to the reporter your opinion on what additional costs there would be to the airport arising from wind farms if EC was mandated, please?
I was a bit surprised by the statement that was made. I have been involved in applying for funding to do research into EC, both the technology, the ATC procedures, and the regulatory framework that goes with it. And that was earlier this year. The idea of EC is that small aircraft and drones announce their position by some means of technology, and that data is then used to enhance the surveillance picture. I'm not aware of any credible means by which any of the technologies that are being considered would be compromised by the presence of wind turbines. They all require some degree of transponder with a small t to be fitted to the aircraft or drone. The technologies that are often talked about are ADS-B, but there are other technologies. There's something called PARC and FLAM, and there's a Pathfinder technology. These are all devices that announce their position, and they would do so irrespective of the presence of wind turbines. Much in the same way as secondary surveillance radar, as Mr. Fido confirmed, is effectively immune from the influence of turbines. That would be the case for this kind of technology as well. So while the airport would have to comply with any regulatory changes that required EC to be put in place, I am struggling to see how the presence of wind turbines would complicate that in any way, let alone result in increased cost.
Okay. Next, Ms. Kilpatrick was talking about issues of long-term risk to the airport and what might be required of the airport by way of a replacement radar in the future. And again, just your thoughts for the reporter, please, on that issue, please.
Well, Glasgow Prestwick Airport itself had a radar for decades that it's managed to keep in service. It does require occasional updates, but there are two things here to consider. So one is what the manufacturer will say as a contractual obligation for supporting a system, and it's called the design life. So when you sign a contract for a new radar, and this is not necessarily a wind tolerant radar, but any radar or other piece of equipment on airfields, the design life is specified and has been typically around 15 years. That does not mean that at the end of 15 years, it's written off and can no longer be supported. Historically, what happens is manufacturers continue to support it, but it might get more expensive to do so. You also find third parties start offering support services to extend the life. So many of the radars in the UK are outside of their 15-year design life, but are still fully supported, as indeed they would have to be to maintain the safety case and CAA approval to use them. That said, I do accept that more modern technology uses COTS items such as switches and servers that do not have 15-year design life. So there may be some requirement to replace servers and IT in a surveillance system, but most airports try and minimize the number of midlife upgrades or any upgrades that have to happen on these systems due to cost. So I think it's reasonable to expect you would get at least 15 years out of the term.
And so far as wind farm tolerant radars are concerned, do you think the position is likely to become riskier or less risky as time moves on?
So I've been involved with looking at wind farm tolerant radars probably since for about 15 years. And in the early days, it was a big headache and there wasn't much out there that could address the problem. Technologies started to emerge from about 2010, of which Terma was one of them. As we move forward in the next decade, it's quite apparent that all the manufacturers are now looking to provide a degree of wind farm tolerance as a standard part of their product. So the situation as it was in the past, where there was no obvious candidate and it was quite a risk, I think was changed substantially. And in 10 to 15 years' time, I expect, rather than seeing increased risk on the availability of technology, I think you'll have a shopping basket of manufacturers' equipment that could address surveillance in areas where you have wind turbines. So I'm probably in the opposite camp. I think the risk is going to go down as the technology advances. And some of the trials that are happening, have happened in the last couple of years and continue to happen, are evidencing that the improvements are being made.
Thank you. And then the final question for now is to do with track capacity. And you heard some evidence from Ms. Kilpatrick yesterday and today about track capacity. Can you just explain to the reporter what track capacity is and whether you think it's likely to be an issue as far as this wind farm is concerned?
So having detected targets and got returns from them, the processing in the radar has to look for a succession of plots that are all related to the same thing, be it an aircraft or in this case a wind turbine. So that takes some computer power, and computer power takes time. So the computer's continuously looking at whether new tracks are there or whether existing tracks need to be maintained. As I understand it, the current Terma can deal with up to 1,000 turbines. And this was from a conversation that we had with them, which would mean that it can handle the tracking in an environment of 1,000 turbines, which is quite a substantial number. If the airport are concerned that effectively these turbines are eating into their headroom, if you look, as Ms. Mackenzie did, at the number of turbines around the airport, I think it was around 500. It's not reasonable to assume that those 500 turbines will be generating tracks simultaneously. The returns from the wind turbines are a result of the direction that the blade is facing towards the airport. And there will all be slightly different positions. So as the wind's blowing in different directions in different wind farms, I would expect maybe 20–30% max to actually cause tracks to be generated within the system. So the number of tracks available, even with the current generation of Terma, is still substantial. And the number of aircraft in the sky around Prestwick, out to a range of, if you take Mr. Fido's range of 45 nautical miles, you would still have the capacity to process several hundred aircraft, which I think is reasonable. If you look at the en route radar network, they also have limits on what they can process, and they are, I suppose, tighter than perhaps you might consider. So I don't see a great problem with the current track processing capability. The conversation we had with Terma, when we asked about this, their latest product, as I understand it, has between 2,000 and 3,000 track processing, a track limit. So it's going to get much better when the airport upgrade it, as they've said they will. That will become the new figure. So again, I'm struggling to see why that should be a problem. We're going to be nowhere near the point where we're constraining the airport's ability to track aircraft because the wind turbines are eating up all the track capability.
Thank you, sir. Those are all the questions I have for Mr. Inglis at this stage.
Thank you. Just give me a moment. No, I didn't have any questions. Mr. Brown, do you want to come back on anything?
Sir, yes, I do have questions for. Good afternoon, Mr. Inglis. Sir, I do have cross-examination for Mr. Inglis, but I wonder, given the updates which have been made in light of the Terma letter, which I've learned of the first time, if I may have a short adjournment of 10 minutes to speak to my expert, sir.
Yes, I have no difficulty with that. We're coming up. We'll take this as our mid-afternoon break and we'll come back at 3 o'clock, please.
Thank you, sir. Thank you, sir.
Mr. Brown, are you ready to continue?
Yes, and thank you, sir. I appreciate that break.
Good, if you want to go ahead then.
Thank you. Hello again, Mr. Inglis. Mr. Inglis, I'd like to start by looking at your report, and in particular at page 12 of your report.
Give me the paragraph reference, because
Yes, of course. I was just making sure you had the page. It's paragraph 361.
three,
And-
sorry, I didn't quite catch that.
And it's paragraph 361.
I'll have that.
Okay. And in the second, well, I'll just read our way into it to get to the point. 361 starts, the GPA radar project was started in January 2015. The contract was awarded that included lot 1 for the provision of a TS 4002 radar that is wind turbine tolerant. And I just want to note for the moment that you have referred to a radar that is wind turbine tolerant. And in paragraph 363, in the second line, you refer to Teesside Airport's operational requirement, and you say that Teesside Airport's OR required a range of 42.5 nautical miles with wind farm tolerance. What the inquiry's heard quite a lot so far of that term, a wind farm tolerant radar, although you call it a wind turbine tolerant radar, but I think we're essentially talking about the same thing. What do you understand that term to mean?
A radar that can be deployed where you've got wind turbines or wind farms within the declared operational coverage volume and provide an operational service.
Okay, thank you. Okay, thank you. Now, in your report at page 4, you have referred to a CAP document which the inquiry has looked at before, which is CAP 764, which is CD 9.4. And I take it that that's a document which you'll be familiar with in your role.
I'm aware of it, yep.
Yeah, and are you aware of its terms?
In what sense?
In the sense, I'm trying to say just how familiar you are with it, if you've got a working familiarity with it.
My working familiarity is more with CAP 670 than that particular CAP, but I am aware of it.
Yeah, okay. And did you consult that document when preparing your report?
No, I don't think I did explicitly.
All right. Well,
I can't remember anything explicitly that was in that document that I put in my report.
okay, thanks.
CAP 670.
That document, if I can take you to electronic page 23. We see there on.
Is that sorry, Mr. Brown, is that CAP 764 we're looking at?
It's CAP 764, and it's 764, and it's. Sorry, we seem to have an echo somewhere in the room. I'm not quite sure. Is that better? Was that your end, Mr. MacLeod? Thank you for clarifying that. All right. Electronic page 23. The inquiry has looked before at this and the concept of mitigation. And we've heard a lot in the inquiry about mitigation. And I've noted that at paragraph on page 12 of your report, at paragraph 362, you have that, Mr. Inglis?
I've got paragraph 362 and I have cap 764 in front of me on my computer.
Yes, I've noted that in paragraph 362, you have said that at a range of 19.5 to 21 nautical miles, 37 to 40 kilometres, the proposed development would be within the existing Thermoscanter radar design limits for providing wind turbine mitigation. So you've also used this word mitigation, and Miss Mackenzie, in her policy inquiry report, which is APP 3.3, there's no need to go to it, but Miss Mackenzie cites in paragraph 95 the definition from the concise Oxford English Dictionary of the word mitigate. And the definition which she quotes from that dictionary says to make less severe, serious, or painful. Now, having regard to the definition of the word mitigation, would you accept that when a wind farm is constructed in the line of sight of a radar, that it's possible to mitigate the effects or the adverse effects that will have on the radar, but it's not possible to totally overcome them?
It's quite a big question. So if the wind turbine was an area of operational interest, and I guess that's the assumption you're making, can you mitigate it totally? In some cases you can. If you use infill technologies, you can provide mitigation that's now commonplace. And I don't think the performance when you're using infill radars is any less than the original in many cases. So it is possible, yes.
With a wind farm tolerant radar, could you overcome them entirely?
With a wind farm tolerant radar, yes, again, if you had deep pockets. I mean, the Ministry of Defence have defence radars that, as you might expect, are able to address these things. So I'm not sure what you're trying to get to here.
Well, would you expect the Thermoscanter 4002 to completely overcome the effects of a wind farm in its line of sight?
I would accept that the Thermoscanter would not 100% address the impact in a wind farm area, yes.
Okay, thank you. Now, Mr. Inglis, you're the first radar expert giving evidence to the inquiry, and there are just a few principles which I would like to check with you first, and forgive me if I'm speaking in broad terms, but this is just to help get an understanding of how radar operates at this stage. So, can we start by agreeing that a radar comprises a transmitter or an antenna and a receiver?
Yes.
Yep. And the concept of radar is that the transmitter will transmit or send out into space a radio frequency signal, or an RF signal as we see in your report, which could also be described as a pulse of electromagnetic energy. Is that what the transmitter is doing?
Correct.
Yep. And the pulse of energy will keep traveling through the airspace until it hits an object. Is that correct?
Correct.
And the idea is that when the pulse hits an object in its line of sight, it will be reflected off that object, and the energy will be transmitted back to the receiver. Is that also correct?
For primary radar, yes. For secondary radar, no.
Yes. Sorry, yes, we're talking about a primary radar. And that returned energy signal will be picked up by the receiver, and that will then be converted And I'm sure there's much more science behind this than just the way I'm about to put it. But what will happen is that when the signal is returned to the receiver, it will be picked up by the receiver and it will be converted in a format so that it can be sent to the display of the radar, which has been monitored by the air traffic controller.
If the signal is of sufficient strength to be detected against the background noise level, then yes, it ultimately ends up with providing ATC with a target on the display.
Well, indeed. And in page 5 of your report, in paragraph 2.1.2, you do say in paragraph 2.1.2, the very first sentence, that the ability of an aircraft to be detected by a PSR depends upon the amount of radio frequency signal reflected by a given aircraft. So
different aircraft, different objects have a different reflection factor, which is the term used is the radar cross section.
yes.
So that's a measure of how reflective it is. So
Yes.
the 1 meter square target is quite small. Some of the turbine blades are considerably more than that in terms of their ability to reflect.
Yes, and that's the issue, isn't it? When you introduce a turbine into the line of sight of a radar, that just as a pulse of energy could be reflected off an aircraft, it can also be reflected off the turbine as well.
Correct. Just because it's in line of sight doesn't mean to say that that will occur. You've also got the antenna tilt to consider. But essentially, assuming that the antenna tilt is set so that the reflection can be captured, and essentially that's how it works.
Yes, so the pulse of energy, if I can just use that term broadly, goes out, hits an obstacle, whether it's an aircraft or a turbine, the energy signal is reflected back. Is it just a matter of straightforward science or physics that when the electronic pulse is reflected back, that it's obviously not traveling any further in space, it's only traveling back to the receiver on the radar?
Well, some of the transmitted pulse will carry on past the object and some will be reflected.
Yes. So if some is reflected, does that not then create a situation where you could have blind spots behind your turbine because your radar pulse is not getting to those spots behind the turbines?
There is a shadow area behind turbines from a primary point of view.
Yes, yes. And is the issue with that shadow area that you might not be able to detect an aircraft which is flying in the shadow of the radar?
Yeah, it's a possibility.
And if we were to look at,
I would just add that losing a single return on an ATC display is not normally classed as loss from an air traffic control point of view. So in the system safety cases I've been involved with, you have to have 3 consecutive or 2 or more consecutive misses before you would class that as loss. So the fact you failed to detect it just once isn't normally considered as a major problem.
all right. Well, if we look at CAP 764, again, Mr. Inglis, and this time at electronic page 22, and we look at paragraph 2.8, and if we look at the very last sentence, which is in the last 2 lines of 2.8, there's a sentence there which says wind turbines can also create shadow above and beyond the wind farm, and that's the shadow you referred to, so that aircraft flying within the shadow may go undetected.
I wouldn't disagree with the CAA.
Now, is that an effect which can be overcome by optimizing radar?
That particular effect, not easily. I mean, the Terma radar works slightly differently in that it does track the turbines, which gives you some advantage.
Yeah, and if you wish to overcome that effect of shadowing, what would you have to do to overcome it?
There's very little you can do to overcome the shadowing effect as described here. So that's why I would say that the Terma could never 100% address as a mitigation. It will never be better than having no wind turbines.
Would one way to overcome it be to install an infill radar which would coverage on the other side of the wind farm or the turbines?
It depends on the geography of the infill.
Okay. And
the wind turbines are really a problem when you have what's actually detected of consequence is the rotating blades, because the blades of the turbine, the tips of the blades move at the same speed as aircraft. So the filtering within the radar system can't distinguish between an aircraft and a turbine. So it's the Doppler element that's the problem. The turbines themselves are not always end on to the radar head, i.e. giving you maximum Doppler shift. If they're front facing, there is no Doppler shift and there is no problem. So it's a little bit more complex than we just discussed. If you want to use an infill, if the infill is such that when the turbines are causing a problem to your airport radar, it's looking in a different direction and can see behind them, then yes, it is feasible to mitigate shadows.
yeah, now, to what extent did you consider the effect of shadow when preparing your report?
So in preparing the report, we relied heavily on the white paper that Terma put together. And we did have discussions with the Terma engineers, and I have to be clear here, we did not discuss Clauchrie directly. We were interested in the results of the white paper, and when I accept in my document, there was a paragraph put in there that was a bit misleading. So from Terma's point of view, we talked generically. And from those discussions, we looked at what we should do to calculate the loss of detection over a wind farm, and that's how we got to the wind farm, the reduction factor that's discussed in the report.
Yeah,
Mr. Fido also accepted that as an approach.
My question, Mr. Inglis, was, did you consider the effect of shadow when preparing your report?
Not explicitly, no.
Now, if I can take you to Mr. Fido's report, and can I ask you please to turn to page 27 and to paragraph. Now, the numbering, well, if we just look at page 27, it's actually paragraph 4 to 8, and it's subparagraph 3. And we see subparagraph 3 starts beneath figure 10. Do you have that?
I do.
Yep. And Mr. Fido says that the static element of a wind turbine will reflect a large amount of energy back to the PSR and will be seen in the CFR process. And because it's in the same place every time, the threshold will increase to stop it being output to the radar display. Now, just stopping at that point, you've mentioned the CFAR process, as it's known. And again, excuse me if I'm speaking too broadly here, but as I understand it, what happens in the CFAR process is that the radar is actually always trying to blank out the constant returns of energy which it's receiving, because it's obviously looking for new obstacles coming into its line of sight. And the issue is that where you've got a turbine or a wind farm, because there's so much energy being reflected back from the turbines, the radar can't then distinguish between the turbines and an aircraft it's looking for in the airspace. Is that broadly correct?
Not totally. So the reflection that you get, as described here,
Yep.
Would be added to the kind of averaging that goes on for the overall number of reflections you're receiving. So the background noise, if you like, gets adjusted to maintain a constant false alarm rate. So it would contribute to that, and the effect would be to raise the threshold. By raising the threshold, any small returns would now be below the noise floor and would not be detected, which isn't ideal. For the term, however, they used the fact that they've detected the turbine to do the tracking, and the benefits gained from that outweigh that slight loss. It's also worth noting that changing in the noise floor level is something that's happening all the time and may happen for other reasons. I mean, if you have severe weather coming in, for example, that threshold would rise. So the level of desensitization we're talking about, yes, it does occur. Is it of consequence? That's something that Mr. Fido and myself could probably discuss at length. But having threshold adjustments on radars is commonplace, and it's a real-time adjustment. They normally adjust the threshold over. It's not instantaneous, but it's over a period of tens of seconds or even minutes that these adjustments are made.
Yes, you mentioned noise in your answer there, and just for us who are not familiar with radar, I think when you refer to noise, you're referring to reflected energy. Is that correct? It's not noise. We would not understand it.
Reflected energy and general noise in the environment that may come through to the receiver.
Right. Thank you. Now, Mr. Fido then goes on to say, going back to his report, and again, subparagraph 3, that the threshold is only held high in the immediate vicinity of the turbine, and therefore the reduced probability of detection is limited to this area. This is also referred to radar desensitization, and I think you referred to desensitization yourself in your answer.
Right.
Yeah. And Mr. Fido goes on in subparagraph 4, in a wind farm with multiple turbines, the CFAR threshold is increased over a greater area because the sampled cells begin to merge. Because this threshold is now greater in amplitude than the returned energy from true aircraft, the radar will not be able to resolve it when the true aircraft passes over the wind farm and will not be visible on the radar display screen. And I think that's the phenomenon which you were talking about earlier. It can be difficult for the radar to distinguish or to pick out an aircraft.
It's a risk.
Yes. And Mr. Fido goes on to say, this is performance degradation that may impact the ATS provided. And then he goes on in subparagraph 5 to say this degradation is often overlooked because the focus is on the clutter that the blades produce. And we've heard a lot in the inquiry about clutter. But Mr. Fido says that the degradation is often overlooked. To what extent did you consider degradation when preparing your report for the inquiry?
We did consider it. I think the extent to which it would be a problem at 20 nautical miles with the size of turbines that we've got and the 500 metre plus separation, we didn't consider it to be a significant effect and a problem. The fact that the Terma tracks the turbines as well, as I said earlier, gives you some advantages for being able to distinguish between true aircraft targets and turbines. So I think that the debate that perhaps Mr. Fido and myself would have is at that particular range over Clauchrie, how significant is this effect? I don't believe it would be that significant. I'd be interested to hear his view.
Yes, we'll perhaps cover that with him. But again, is that an effect which you can overcome through optimizing a radar?
Yes, to some extent, if you're willing to accept a higher false target rate and allow, in other words, the threshold is lowered, so you do get more noise stroke small returns going through the processing and being displayed to ATC. And that has been done on some of the major radars in the UK, where it was deemed more important to maintain detection of targets in exchange for beating up some of the background noise.
And if an air navigation services provider wished to overcome the effect of degradation, how could they achieve that?
Within limits, as I say, you can accept that you're going to have a higher false target rate. So modern radars now, you tend to have a very, almost looks like a computer game because the screens are so clean, and false target rates are very, very low. You tend to only see true targets. I'm ignoring the wind farm effect just generally. But if you're willing to tolerate a slightly higher number, then you can get a little bit of a gain in terms of overcoming the desensitization issue. And that has been done.
Okay, so can we take it from that answer that there's no perfect solution to that issue?
I think when it comes to optimized radars, that there are always trade-offs. I haven't been involved with radars yet that haven't had some kind of trade-off in the optimization process. And I think accepting a higher false target rate to avoid some desensitization is a reasonable thing to do. I'm not sure if I'd class that as good or bad. I would say that was just an available lever that optimization specialists would pull.
Okay, thank you. Going back to Mr. Fido's report at page 27, and it's subparagraph 6, he says the impact on the radar display is that the video slashes from a moving aircraft will disappear from the radar display over the wind turbines. Figure 11 shows that true aircraft returns are missing over the turbines. The rotating blades remain because they are both moving and greater in amplitude than the resulting threshold. And then he goes on to say on the next page in subparagraph 8, in the case of the Terma radar, the same effect is also true. And the result is there will be no plots over the wind farms and therefore no information to the tracker. And then he continues on subparagraph 9. The net result is that in the vicinity of a wind farm, the probability of detection will be reduced from what is operationally acceptable to the airport. So Mr. Fido's there considering the topic of video desensitization. Did you consider that when preparing your report for the inquiry?
I did. I think I agree with Mr. Fido in a lot of these areas. I've got a lot of respect for him. The bit that in subparagraph 9, it's the operational acceptability of that is probably the challenging issue for the reporter. So some of these effects do occur. I mean, when you get heavy rain, things desensitize, your range can reduce on radars. There are lots of things that happen that are operationally acceptable. And I believe over Clauchrie, having spoken to Terma, that while these effects may take place, that the reduction overall in the ability to detect targets is well within what could reasonably be expected for ATC at Glasgow Prestwick to be able to provide a service from.
Yeah, but when you say that, you're expressing a view on the operational requirement of Prestwick.
I am, yes. I mean, I think the operational. I'm a bit unclear on what the operational requirement is. I have to say, the 2015 tender process. I thought from Mr. Fido's submission, the requirement was for 45 nautical miles to be used operationally, not to be confused with instrumented range. So this means that within 45 nautical miles, I'd expect a 90% PD and a low false target rate. So I thought initially that's what you had purchased in 2017. So I'm a bit surprised you're now doing an upgrade to achieve that. So I don't know definitively what your operational requirement is, but I have worked on radars a long time ago at Prestwick, and I think some of my colleagues, Mr. Wiley, has mentioned that the existing radar does have quite a lot of false targets on it, and other limitations like seeing lorries on the highway that are tolerated at the moment and provide, in providing a safe service. So you're right, I haven't got a definitive answer, but I do know that Prestwick in particular, of all the airports in the UK, has had quite a challenging surveillance system for many years and has continued to provide a safe service.
Now, going back to Mr. Fido's report, and this time, if I could take you to page 9, please. And this is a sub-paragraph, and I'll not take you through the numbering, but it's paragraph 2.2.2, subparagraph 4, subparagraph C, which we see at the top of page 9. And there, Mr. Fido says, to date, I have yet to discover a mitigation technique that can mitigate all wind turbine effects without some level of degradation or compromise, though the term Scanter 4002 is probably the nearest to that ideal. In light of the answers which you have given in respect of shadowing and degradation and video desensitization, would you agree with Mr. Fido's conclusion there?
Are you saying, do I agree that the term is nearest to the ideal?
Yes, I'll just take that.
Agree with, I'm not sure.
I'll take that more slowly. Mr. Fido says, today I've yet to discover a mitigation technique that can mitigate all wind turbine effects. Would you agree with that?
In the civil world, it's probably true. I'm hesitating because some of the more recent technologies are looking quite promising, and I haven't had a chance to look at them in detail. On that list, for example, the Henselt one, they're making some significant claims. The latest Thales, similarly. So I'm not 100% sure. Things are getting much better than they were 5 years ago. I'll give you that.
Although Mr. Fido is clear, he's saying to date he's yet to discover a mitigation technique that can mitigate all the wind turbine effects. So in the same way that Mr. Fido has answered that, to date, would you agree with his comment?
I think if you look back at the technologies over the last 10 years, it's fair to say that all of them resulted in some level of degradation, or as he puts it, compromise. I'm just a little uncertain about what's currently out there, because I am aware of some quite significant steps towards now. But I haven't got any, I don't violently disagree with the statement, no.
Okay, thank you. Now, on the question of electronic conspicuity, Mr. MacLeod asked you various questions about electronic conspicuity, and I think you said that you didn't think that if electronic conspicuity was mandated, that any special steps would be required on the part of the airport. Now,
that's not quite what I said.
okay,
I said obviously if and the published documents they were aiming for 2023, which is just around the corner, to start putting EC in place. What I said was, as a direct result of having wind turbines and wind farms at Glasgow Prestwick Airport, I couldn't see any factors that would complicate the implementation of EC.
Would the shadow effect not again have be a problem for the airport?
No.
Well, what if smaller aircraft are fitted only with standard mode S EC capability?
As Mr. Fido says, and I agree with him, there is no impact on secondary surveillance radar. Aircraft are not allowed, and I'm going to touch on ATC stuff, but which I'm not an expert in, but I understand that aircraft would have to be a minimum of 500 feet above the turbines. And if you have a radio on board an aircraft, you'll have direct line of sight back to the head. So it's a different kettle of fish when you're talking about things that are actively transmitting their position to things that you're relying on being reflected. So I'd be interested to hear, Mr. Fido, if I have missed something, but I'm really struggling to see if SSR is not a problem, why EC should be a problem, because the principles are much the same. They transmit their position, and so I really don't understand how that can be a factor.
Well,
To the airport, but it's not a cost that that is increased due to the presence of wind farms.
well, there's not a risk that the presence of the wind farm would block the coverage behind the turbine, behind the wind farm.
I just don't see it because they're not allowed to fly that low to sit behind it.
Okay, so
if they're flying that low, they're in breach of safety regulations. You're not allowed to, and even if they were sat immediately behind a turbine blade, I still think they would be detected, but they just won't happen. They cannot be. It's a different animal, primary radar and secondary radar, and EC is more aligned to secondary radar, and as Mr. Fido says, that's not affected. If I've missed something, yeah, I'd love to have that discussion, but I really am struggling genuinely to see how EC and wind farms have got any relationship whatsoever.
So if we hear from Mr. Fido when he comes to give evidence that he believes that more sensors would be required behind the wind farm, you would disagree with that statement?
I would, because some of the EC technologies, they don't even rely on line of sight from the aircraft or drone to the airport. So if you take drones as an example, one of the things that's being considered is the drone operators that may be situated centrally in the country somewhere and operating drones hundreds of miles away. They know the position of the aircraft, and they know it because of satellite links, because of using the mobile phone network. Those drone positions then get collated centrally and displayed to the drone operators at a remote location. So you don't even need line of sight in those circumstances between the drone and the airport, because your source of data is coming via a completely different route.
All right, well, we'll hear from Mr. Fido. And if I can take to paragraph 132.
Sorry, I lost you there for a second. Which document are we looking at now?
Oh, sorry, we're looking at Mr. Ingles's recognition.
Thank you.
And it's paragraph 132, sir.
Thank you.
Where Mr. Inglis has said that Mr. Fido misrepresents the CAA requirement, and figure 9 claiming incorrectly that the PD requirement relates to a single aircraft track. PD is calculated for the declared operational coverage volume. Now, Mr. Inglis, are there not two issues there? There's first of all the probability of detection of an aircraft, and separately there is the probability of detection in the declared operating coverage of the radar. Are they not different concepts?
They are, so it's important not to confuse them. The recommendation for 90% relates to the declared operational coverage volume. And indeed, it's only a recommendation, which was the point I'm making there.
All right, can I take you? If I could take you, please, to a document we've looked at before, the one you've said you're familiar with, which is CAP 670. And if we could look, please, at this document so large that it only makes sense to look at the electronic version. So it's electronic page 407. And this is about the performance of...
Sorry, Mr. Brown, what's the reference number for this document?
Well, this document, sorry, it's CD 9.3.
Thank you.
And it's page 407, electronic page 407. And we see on electronic page 407, we have reference to the performance of PSR systems, and which is at SURE 04-7. And we see just below that performance monitoring of PSR. Now, what I'm interested in are the notes which appear in SURE 04-7 and SURE 04-10. And do we see there is reference in both of those sections to an ICAO document, ICAO document 8071? You have that? And indeed, if we can look at electronic page 550 in that document, and this is the SURE 13A section. And just to set the scene for this, hopefully it won't be controversial, but this section, SURE 13A, is dealing with safety oversight of wind farm mitigation techniques implemented by ANSPs. And do we see again in that page, which I've taken you to, paragraph SURE 13A 246, and again we see reference to ICAO doc 8071. Do you have that?
I do.
Yep, thank you. Right, so does that then mean that it's possible to look at ICAO document 8071 to see what's expected when it comes to the testing of PSRs?
You could do, but I doubt I disagree with anything in there. So whether it's you could read it verbatim or not, I'm not sure.
Right, okay, well, let me take you to...
The way it's structured, ICAO obviously are the international body, and each national regulatory body then interprets the requirements. So CAP 670 itself goes into the detail of how the UK complies with the ICAO requirements. So CAP 670 is normally seen as the definitive regulatory document.
Yes, but you can refer to ICAO. Sorry, you can refer to ICAO 8071.
If I'm doing a radar project.
Yeah. Now, if we go to that document, which is CD 920. And we turn to electronic page 38.
Timed out. If you read it out to me, that would be more helpful. I've just timed out on my access. So.
Okay, well, right, well, I'll read it out to you. electronic page E38 or E38. There's a section there which is section 3.2, which is definition of radar systems performance parameters. And there's a general section 3.2.1, which says from an all-over system point of view, the parameters which require evaluation to determine the performance of the system are categorized as follows. And then we've got A, coverage, and B, we've got detection performance. And then we've got two others, and I don't think we need trouble the inquiry with those. But the document continues in paragraph 3.2.4 when it deals with coverage. And it says that the coverage of a radar system is the three-dimensional volume of airspace within which the system can meet the specified detection performance, accuracy and resolution values depending on geography and chosen variable parameters. So we have that. But it goes on then in that section. It's an unnumbered paragraph, but there's then reference to detection performance. And it covers probability of detection, or PD, as it's often put for short. And it says, note, the probability of detection, PD, is here defined as the probability that each scan for a given wanted target within the coverage measurement volume, a radar target report with position data will be produced. Now, just give me a moment. So, there are various concepts which are considered there. So, first of all, it talks about the probability at each scan. Now, just to help the inquiry with that, when it talks about each scan, am I correct in understanding that what's been referred to there is that the radar obviously spins round and it makes one revolution every 4 seconds, or sometimes that's referred to as a sweep. And that would be a scan for the purpose of this, as the radar sweep.
Yes, I mean, these are kind of old terminologies because radars were mechanical and rotated and at various different speeds.
Yeah.
More recently, we've moved to update rate as a phrase, but
Yeah.
EKR was still on the scans.
Yes, and the next thing which is referred to, the next concept here for those of us who are still learning about this, is that for a given wanted target within the coverage measurement volume, and when this refers to a given wanted target, it's essentially talking about an aircraft in the airspace, because that would be a wanted target.
Okay.
Is that, yeah, that's fine. And then it says that a radar target will report with position data will be produced. And when it refers to the radar target report with position data will be produced, having looked at screens from the radar at Prestwick, the old TS511, we noticed that there were slashes, and I think they're sometimes now referred to as blobs, as the aircraft moves through the airspace, and that would be a radar target report, would it?
Yes, that would be a radar target report for a plot extracted radar.
Yeah. And turning to the next page, paragraph 3.2.8, there's reference to PSR position detection. And it says here that the probability of detection of the primary radar is defined as the ratio of the number of detected PSR target reports to the expected number of PSR target reports. Now, when that is referred to in this ICAO document, correct me if I'm wrong in this, please, but what it's saying is that it's looking, as the radar sweeps round, the radar will expect a report when it detects an aircraft, and you can expect that every sweep or rotation of the radar. And what this formula is doing is looking at the number of actual returns you get, or slashes or blobs, compared to the number you would expect. Is that correct?
Correct.
Yeah. And if we go on to page E44. We've got in table 3.1 typical overall performance figures for primary and sliding window SSR systems. We're obviously not dealing with an SSR system, but we can see here that the target detection probability on PSR, according to ICAO, is typical performance figure 85 to 90%. So, Mr. Inglis, having reviewed ICAO 8071, does that not mean that Mr. Fido was correct in his interpretation of what probability of detection means?
No, the point I was making, he said in his report that the 90% was recommended by the CAA or mandated by the CAA. The 90% that they're referring to is the probability of detection over the declared operational coverage. That was the point I was making. I agree that there's that PD, and there's also something called a track PD, which is the probability of detection of a single aircraft track that you've just led us through. But there is no recommendation within the CAA for what the track PD should be.
Well,
CAP 670.
We've heard from the various evidence we've heard so far about the fact that the airport has to account to the regulator. If the airport was unable to say to the regulator that it had achieved a probability of detection of 90%, how do you think the CAA would react to that?
It's not uncommon. It has happened. And you have to do, as you indeed just read out, you have to do a risk assessment against the operation, the service you're providing. So missing by a few percent in just one area, as long as you can make a sensible safety argument, would not be a problem, and is normally a problem because it's not uncommon.
All right, but some explanation would have to be given for the CAA as to why the recommended performance had not been achieved, would it not?
More than the explanation, you'd have to do a proper safety assessment to make sure that that minor reduction is indeed acceptable and you can provide safe operations. I think in my report, I did labour the performance of the 511 considerably. And that was really to say that the 90% it's not a hard number because the CAP 670 does allow you to do to have a PD as long as you can provide a rationale for it. You might elect to take the recommended 90%. You might take 85 or indeed 80. And at Glasgow Prestwick in the past, they have accepted and provided service with a much lower PD. So I wouldn't like the reporter to think this is an absolute pass-fail criteria, because it's not, and CAP 670 recognises that.
Okay, well, you mentioned there the performance of the S511, and you do cover that in your recognition at paragraph 1.8.3. So if we could have a look at that, please. And you have, as you've just said to the inquiry, made it clear there that in the third line of that paragraph, for nearly 30 years, the operational S511 hybrid radar provides safe operation with a PD of 80% with high levels of clutter and false tracks from vehicles. Therefore, the current requirement for PD must be 80% throughout the declared operational coverage volume. And then you go on to say, well, the TS 4002 is specified to achieve a PD of greater than 90%. A small reduction in PD from this figure should not preclude its operational use. Now, on that point about the 80%, is the 80% not what the manufacturer warrants the radar will achieve?
No, I'm
No?
not sure what you're trying to say. For the 511, when the
Well,
511 was updated in 1993, there was no manufacturer responsible for doing that. It was the CAA themselves, and my department in the CAA, and my colleague Peter Hotham, who now works for Zazar. He was the engineer responsible for it, and Marconi were involved in changing the antenna, and some other changes were made as well. And then the CAA themselves took the responsibility, as we now know it, for the performance of the radar. And at that point, I suppose the CAA was both the provider and the regulator. And from talking to my colleague, 80% was what they targeted and struggled indeed to achieve. In fact, they only managed to achieve it by accepting the high false target rates at that time and having lorries visible on the local roads, which I still believe are present today.
but
It's a hybrid product. There was no single manufacturer that would, it's not like a new radar project where you buy it from a major manufacturer against some terms and conditions and they have to meet it. It wasn't that environment at the time.
yes, so what's happened over time is there's been a change in the view of the regulator. At the time the PS511 was acquired, there was no PD rate, but we now have the CAA saying it should be 90%.
We don't.
Sure.
We have a recommendation of 90%, but it's up to the ANSP if they want to have any PD to have a rationale for the basis of that decision. And one of the ways of doing it is to refer to standards. You could make a safety argument for accepting 89%, 85%, indeed 80% potentially.
But is the airport not, in fact, even with its PS511, not achieving a rate of greater than 90%?
I think Mr. Fossey believed it was. There was no evidence provided to support that. And the problem with the 511 is it's an analog radar, so it's quite difficult to do the PD calculation. Back in when the system was commissioned, you had two air traffic controllers sat side by side for 2 weeks, and they would literally say hit, hit, miss, miss, and record it on a piece of paper. And then 4 weeks later, they would do the sums and tell you the answer. It's quite a piece of work to establish the PD of an analog radar, and I'm not aware that exercise has been done since '93. Again, I've welcomed Mr. Fido's view on how that might have been done more recently. With plotted static radars like Terma, you can put radar analysis tools, basically computers that will analyze the data for you, and you can get some results within a matter of days and over a much larger sample of traffic.
Well, you mentioned the fact of how you do it on an analog radar. And the PS511 is an analog radar, and I think you said yourself there that the only way to do it on an analog radar is to count the number of slashes or blobs which you get on the screen. Is that correct? Is that what you said? Just want to be clear about that.
Yes, that's what used to be done. It was very time consuming and expensive. And then the independent body would produce a report, and on the basis of that report being acceptable or not, the radar would enter service. And at the time, that was all done under the banner of the CAA.
You'll be aware, Mr. Inglis, that the airport has lodged video recordings of the PS511 in operation, and we had a look at those earlier in the inquiry, but we saw on those videos that the aircraft which were producing returns on the radar, and would they not show a greater than 90% probability of detection?
No. So the volume, the declared coverage volume PD requirement, 90%. You can't just take a sample of one aircraft track and say we saw it 16 times out of 16, therefore the PD is 100% within the entire volume. if you go to the track PD that we discussed earlier, you still can't do it on a sample of a single aircraft over just 16 scans. It's too selective. You would have to do much more analysis than that. Now, I'm not saying that if you did do more analysis, you wouldn't get the same answer, but selecting a single track of 16 scans and saying it saw it every time, therefore it's 100%, it is not how it should be done.
But did you not say that that was the only realistic way to do it in an analog radar?
It is, but you do it for much longer. So if you've got a 45-mile range, you would track the aircraft coming inbound and going outbound, and you do the hit miss all the way across the top of the radar and back out again. That's much more than 16 scans. With it,
Yes.
if I did that, if I flew an aircraft in and outbound on a radar with 45 nautical miles, and I just selected the bit where I got 16 out of 16, that wouldn't give you an honest representation of what the true track PD within the coverage, even for a single aircraft track is. And that's my point, really. I'm not saying it isn't, I'm just saying you haven't really got enough evidence from 16 scans in one aircraft.
Yes, but is that not the point, Mr. Inglis, that you don't actually know what PD the airport is achieving at the moment, do you?
I don't, and I'm not sure the airport do either, but maybe Mr. Fido could confirm they've done a proper assessment and can provide that figure. But I go back to my point was, because the 511 is time served and somewhat urgently needs replacing, we're now focusing on the Terma and the implications for that. I was just trying to draw the bigger picture for the reporter, that these numbers are not absolutes, and that many air traffic services are provided where the PD is less than 90%. And arguments can be made, safe services can be provided with a PD less than 90%. That said, I would still target 20%, and Terma's own specifications say they would achieve it. But if there's a slight drop by 1 or 2%, that's not uncommon, and arguments could be made. And Prestwick in particular has been used to living with radars with high false target rates and reduced PD. So for Prestwick specifically, not knowing it in any detail, as you point out, I would have thought they're better placed than most to be able to tolerate that.
Mr. Inglis, you said there that the airport has been living with reduced PD, but you said earlier that you don't actually know what the PD is for the airport.
I don't know now, and I haven't been given the evidence. I'm going on my knowledge of the radar bit when it was commissioned, the performance of the 511, and the fact that Mr. Wiley's evidence confirmed that there were high false target rates, the vehicles on the road, for example. So you do have a higher clutter level on the screen than you would expect at the moment from a modern radar.
Yes.
And
yes.
I think Mr. Wiley also said that the radar performance in certain areas wasn't that great.
Yes, but you would accept that. Sorry, seem to have a problem with the sound. But you would accept, Mr. Inglis, that Mr. Wiley left the airport 6 years ago, did he not?
He did. But radars, when you optimize a radar, you try and get every last bit of performance out of it. You squeak it as much as you can. So the radar, when he left, I like to think whoever optimized it last would have got it to its maximum capability. And if that maximum capability included high false target rates, lower PD, and areas where the performance was such that you picked up vehicles on the road, unless you've done something really dramatic with the 511 in terms of processing power, receiver sensitivity, transmit power, I just can't believe that would have changed fundamentally in the last 6 years.
Well, the fundamental fact remains surely, Mr. Inglis, you just don't know what the airport's achieving today.
I don't, but I'm very familiar with radars, and as I just said, unless you make a dramatic change to some aspect of the radar, the performance 6 years ago will be substantially the same. Because otherwise you would have implemented it, you know, when you first optimized it or subsequently optimized it. So you're right on a pure point. I don't absolutely know, but as somebody that spent a long time with radar, to see a step change without making any significant changes would be quite difficult to understand.
Okay, thank you, Mr. Inglis, sorry. Sir, I'm conscious of the time and I probably have another 3/4 of an hour of cross.
Well, we've got all day tomorrow. I think, yeah, I'm reluctant to go on till 5 o'clock. I think I prefer to stop before then. So if Mr. Inglis and Mr. MacLeod are content to break now, then I'm content to do that. Mr.
I am, sir. I wonder whether we might start at 9:30 tomorrow, if that suited you, and then that means that there's. I mean, I think we will still comfortably get through Mr. Inglis and Mr. Fido tomorrow. I've a practical issue in that Mr. Inglis is on a train around 3:30 tomorrow afternoon, and ideally I'd quite like him to be here to hear all of Mr. Fido's evidence. I don't expect to be still asking questions at that time, but I've been wrong about these things before, and I wonder whether starting at 9:30 mitigates that risk.
Oh dear, that word again.
Well, we talked about mitigation, yes. Well, if there's any worry about time, let's go on for a bit longer tonight as well, and then.
Well, sir, no, I think we'll comfortably finish tomorrow. If we start at 9:30, that should be ample time to allow Mr. Inglis, sorry, to leave in time to catch his train.
Very well then. We'll do that. We'll stop now and we'll come back at 9:30 in the morning. Thank you.
Appreciate it. Thank you, sir.
Thank you.
Good night.
Good night.